We're here to resume the hearing of the PDP, now the subject of variation, and also to hear Plan Change 19 of the ODP. I'm accompanied by Commissioners Sinclair, Williams, McMahon and Pomare. My name's Trevor Robinson. I'm the Chair. Mr Wakefield, Ms Viskovich, welcome on behalf of the Council. Are there any preliminary procedural issues that you wish to raise that we should canvass?
No procedural issues.
Mr Hastings, is there anyone on the line? Doesn't sound there is one preliminary procedural issue that I wish to put on the record, that because of the other commitments of the Commissioners, we've made arrangements following the conclusion of this hearing to hold preliminary deliberations while everything's still fresh in our minds. Obviously, that's going to be before we have the Council reply, so we won't make any final calls. But what we would be assisted by is if we could, as we identify them, if we feed questions back to the Council team arising out of the matters we're hearing, if the Council team are able to answer those questions in short order, in order that we can consider them as part of our preliminary deliberations, that will assist us immensely. That's obviously without prejudice to what any second thoughts the Council team might have in their written reply. So instantaneous reaction is good on an all care and no responsibility basis. I think that we have largely got 3 days devoted to the Council case, but we do have two submitters, or three submitters, one combined team from the retirement industry, Ryman Healthcare and Retirement Villages Association, the end of this afternoon, and also from the Ms Sterling from the Ministry of Education first thing tomorrow to accommodate their particular timing constraints. But Mr Wakefield, over to you. We have your legal submissions. We've all read them, so I don't want you to read them to us. But if there's anything you particularly wish to highlight before we ask you some questions about that, the floor is yours.
That's a very helpful indication, sir. I'm glad you had the time to find the homework reading enjoyable, I hope. We have reviewed the legal submissions filed by other parties, and my friend Ms Viskovich has prepared some notes that just broadly capture the central theme of the Council's case and its approach, and respond to a couple of points raised by other parties.
Key question, Ms Viskovich, before you start, are your notes in a position that you're going to be able to give us a copy in order that I don't have to write down everything you say?
We certainly can provide you with a copy in due course. What I might do to begin with, though, is to hand over to the Council team who are going to provide you with a brief overview, Mr McDonald and Mr Racklin in particular, of this particular, of the matters that are being considered as part of this hearing stream. So I'll hand over to them now, and then if it pleases the panel, then we will present our legal submissions after that.
If I could correct you, it's a failed rule 1 for lawyers. Know who your client is. It's Mr McDonnell.
Both pronunciations work. Depends what part of the world you're in. Ngā mihi nui kia koutou. Good to see you all this morning. We thought it would be useful to give a quick run through of the team in the batting order and give a brief overview of Variation 1 and Plan Change 19, just to get it fresh in everyone's heads before we start, and then throw directly over to the legal team. My name's Tori McDonnell, I'm Principal Policy Planner. I'm going to introduce our team and some of our expert advisors, one of which is just wandering in. Run through a quick few procedural matters, and then Michael Racklin and I will give a quick overview of to set the scene for the panel of the Variation 1 and Plan Change 19. So first of all, we have legal submissions from our counsel, Mike Wakefield and Catherine Viskovich. Following this, we plan to run through our respective 42A reports, which make recommendations on submission points received. Each officer intends to outline some of the key issues in contention at the start of their topic, and we're available to answer questions from the panel. As outlined in the hearing schedule, the first report will be the overarching Section 42A report. So I authored the bulk of this report. I have one expert on hand, which is Mr. Alistair Osborne, who just arrived. He's a senior hydraulic modeller for Wellington Water. My colleagues, Michael Racklin to my right, Caroline Racklin to my left, and Rory Smeaton to her left, also authored sections of the overarching 42A, so they're available to take questions. Mr. Racklin has two experts supporting his analysis, so Mr. Graham McIndoe over on the bleachers, and Phil Osborne, who is an economics expert. So Mr. McIndoe's urban design expert, of course, and Phil Osborne is an economics expert joining via Zoom. Mr. Racklin proposes lifting a couple of his topics from the Section 42A report to immediately follow the overarching Section 42A to help the flow of the discussion. Two issues he's identified, which would be good scene setters, our approach to walkable catchments, and the role of urban design guides. So we're hoping the panel supports that approach. It might be a little out of order from the residential Section 42A report. Sorry? Yep, if time at the end of the day, correct. And Ms. Racklin has two experts in support of her analysis, Greg Vossler and Ian Bowman, and they will both be appearing via Zoom, so they're not here today. So I know our presentation on the overarching 42 will be broken up by the presentation from the Ministry of Education tomorrow morning. Following the overarching Section 42A, my colleague Mr. Racklin can work through his two reports that he authored on the residential and commercial zoning. And again, he'll outline key issues in contention and take questions from the panel. Following that, Mr. Smeaton will present 4 of the Section 42A reports he has authored. He has a range of experts available to answer questions on the Northern Growth Development Area, and I understand they're all appearing via Zoom. None of them provided written expert evidence, but they're available to answer questions from the panel if needed. And finally, I will present the Section 42A report on Plan Change 19 for Plimpton Farms, and I have no expert advisors supporting me. Happy to take any questions from the panel on that approach for the next 3 days.
I'm sure that we'll work it out as we go along, Mr. McDonnell.
Great. I just wanted to quickly raise a couple of procedural matters. So Variation 1 and Plan Change 19 were notified on the 20th of August 2020. We received 115 submissions and 25 further submissions. I note that paragraph 98 of the overarching Section 42A has a typo where it says 118 submissions, so I just wanted to confirm it was 115. The summary of submissions was notified on the 20th of October 2020. This included a summary of decisions requested for 114 of these submissions. So there was one that had not been summarised. This was outlined in the addendum to Section 42A dated 23 February. That was from the Whitby Lakeside Villas Body Corp. So we omitted summarising their submissions, and we provided a memo to the panel apologising to the panel and the submitter for this error. So that submission has been designated as submission 115 in the addendum, and it's just a single submission point. Further, one of the submissions summarised in the 20 October summary of submissions was not included in the 42A report. That was the submission from submitter 35 Te Whenua Ora Trust. And we made recommendations on that submission point in that addendum. Finally, as outlined in the addendum and in our memorandum to the panel dated 24 February, Council decided at a 24 February council meeting to withdraw flood hazard maps for the Waiohata Duck Creek catchment. Council has subsequently drafted a public notice pursuant to Schedule 8D of the RMA, and that is being submitted to the newspapers this week for publishing, and the flood maps will then be removed from the E-plan, possibly before these hearings end. I'll now pass over to Michael Racklin, who will give you a quick flyover of the city and what Variation 1 hopes to achieve. We intend this just as a scene-setting introduction. Mr. Racklin's happy to take any questions, but we suggest the substantive questions are directed to him when he presents his report this afternoon.
Good morning, panel. So I'm just going to do a brief overview of the key points of Variation 1. I don't propose to touch on PC19, which I'll leave to Mr. McDonnell. So I've got up on slide just some of the key highlights of what came in by way of Variation 1. So I'll just quickly go through those. So there's a suite of changes that were made to implement the requirements under the section 77G. So that's amendments to the strategic objectives, the rezoning of the city centre zone to a metropolitan centre zone, the introduction of a high-density residential zone and a residential intensification precinct to invite increased intensification, the rezoning of all remaining residential areas to medium-density residential zone, and that involved the consequential deletion of the general residential zone. Then the introduction of a hospital southern development precinct to enable greater building heights in the hospital zone. It also introduced site-specific height increase controls to enable increased building heights in qualifying locations within the commercial and mixed-use zones. There are also, in addition to that, controls were placed on building heights and or heights in relation to boundary for sites adjacent historic heritage sites, sites in areas of significant Samari, and on steep south-facing slopes, as well as around the Mungavin netball court facility. The variation also sought to introduce a more enabling framework for buildings in the commercial and mixed-use zones, and also the general industrial zone, and also to introduce a more enabling land use activities framework to manage the distribution of land uses across commercial and mixed-use zones. The Northern Growth Area development area is also to be rezoned to live zones through the variation, and also new flood maps were introduced as well. So I'm just going to do a flyover of the city in terms of the zoning. So this is a tool that we developed as part of for submitters, so they could identify more easily what was proposed for their actual property. So it's a sliding tool that, in that view, is showing the PDP zonings. So I'll just bring them up a little bit closer. A little bit. That is as proposed under PDP. So city centre zone, the large format zone, and this purple colour is general industrial zone. This pink colour is the mixed use zone. The lighter yellow is all general residential zoning. it's hard to see on this, but there is patches of orange. Maybe if I bring it in a little bit more, where the medium density residential zone under the PDP was proposed. So larger as in the east around the local centres. Up in Tai Bay. And there's also a medium density residential zone proposed up in Plympton. So if I just, but this, give it time, will be, so under variation 1, so the city centre zone becomes a metropolitan centre zone, and then this dark orange is the high density residential zone. And you can see this is the Kenepuru landings site, and then it extends into eastern Porirua, up into Elston. All the other land around becomes medium density residential zone. I will show you the precinct overlay that sits over that. But it's a different layer. So going northwards, so high density zoning proposed at Mana and Plympton. And then if we travel northwards, Porirua Bay, this is the northern growth development area, and it's maybe easy if I show PDP layer. And that shows the extent of it in there. So I'll just take us back down to the main part of Porirua. Just to illustrate the intensification precinct. It's not as easy to see because of the symbology we have to use under national planning standards. It's easiest done when I enlarge. So this is eastern Porirua, and this is where around all the local centres we upzone pledged precinct to enable 5-storey buildings within this brown dotted line. So you see this in around the local centres of Porirua, eastern Porirua. Then if we go outwards to Whitby, all these areas here are subject to that intensification precinct. And then the other main location is up into Tai Bay. So that's a very brief overview of variation 1 in terms of the zoning and precinct patterns across the city.
And just quickly, plan change 19 to keep it fresh in everyone's mind is so that applies to the Plympton farm site, which is a 360 odd hectare site in Plympton. It was rezoned through plan change 18 to the operative district plan to a range to one zone, the Plympton farm zone, with a range of precincts. And when the MDRS got introduced to the RMA, we considered that it was necessary to bring those into the Plympton farm zone as well. So plan change 19 is to the operative plan. It inserts the MDRS into the 2 residential precincts A and B, as well as a high density sub precinct and precinct A, which is a walkable catchment to the Plympton train station. So the high density sub precinct is equivalent to the high density residential zone, so it enables up to 6 stories, and MDRS is enabled throughout precincts A and B. And the only other There's precinct C that has a range of sub-precincts that's up higher on the hills in Plympton farm site, and that they're more akin to a rural residential or rural lifestyle type zoning, so we didn't introduce the MDRS into those. So that concludes our brief overview. Hopefully it assisted the panel and anyone listening in as to our overall approach. And unless there are any immediate questions, we'll throw over to Council.
Go.
Thank you, Mr. Ackland. I had a high-level question for you, and just excuse me if this sounds a little bit fundamental, but I just want to get it clear in my mind. With the general residential zone on the PDP and its transition to how it's dealt with in Variation 1, is there any residual GRZ left in Variation 1, or has it all been divvied up between medium density and high density?
It's all gone. It's all divvied up to the new zones.
Okay, thank you. And secondly, with the residential intensification precinct, did I hear you right, so that was around local centres?
Yes, that's correct. So it's around the local centres to implement that part of the Policy 3,
Yes.
which relates to enabling adjacent local centres.
That's D, is it? Does that
It could well be, it sounds correct.
But it's not a mandatory.
3D.
Yeah, it's not done under 3C as a mandatory.
Not under 3C, it's done under 3D.
Thank you. And do I hear you say 5-storey buildings in the residential intensification? What does that equate to in terms of height?
Height is 18 metres.
Okay. And just very briefly, what was the metric used to define the spatial area?
So that was based on the 800 metre walkable catchment, and then we had two well-functioning qualifying factors that overlaid that, and that's access to local parks, and by that we mean active parks where you can play rather than reserves, and also to walking distance to primary schools.
Primary schools, okay. Those two qualifying matters are being used elsewhere with a 400 metre radius, haven't they?
So to the local parks is 400 metres. That was used to help define the high density residential zone in.
Yes. Thank you.
Just a clarification from me. When you said qualifying matters, did you mean with a capital Q and a capital M, as defined in the section 80E?
No, that term is comes from Commissioner McMahon. We've used it as part of our
Yes, yeah, you can blame it.
methodology. We're saying it's part of our methodology for identifying and implementing Policy 3 in a way that achieves the objectives of the MPSUD.
Happy to take the blame. Thank you.
Any other questions rising from that overview? Very helpful, thank you. One final question, Mr. Ackland, arising out of your supplementary evidence, I wonder if you should just take us through the areas where you've shifted ground on zoning issues, just as give us an overview so we know exactly where you're talking about.
So the main... So there's two locations where I've recommended a 36 metre height limit. The sites are in my supplementary, but they are located, let me just enlarge that a bit more. So over to the east of the Mungavin interchange, so over in here, that's the state highway passing through here. And then the other location So this piece of land here would become high-density residential zone. And I'd have to just check my supplementary for the precise, because it's hard to tell it on that plan.
But
compared to the
that's
alpha.
that. Like, we'll talk about the detail when you get to your
But
supplementary.
generally,
On an overview basis,
Yeah.
right.
So it's at the round in here, getting close to the city centre.
Excuse me, Mr. Rackman, can you remind me, have you got a map attached to your supplementary showing us where those areas are, or is it just in words?
No, there's
The maps are there.
maps with it and aerial photographs with the outlines dotted, taken from Mr. McIndoe's evidence.
Paragraph 19. Mark. Paragraph 19.
Mr. Reckland, that's a nifty little tool you have there. Is that available to the commissioners?
Well, it's online, so I could ask Jack to
Perhaps
send
Mr.
you a
Marshall.
link to it. It's a live thing that's kept on the site for the public to use.
Oh, thank you. It would have been quite helpful.
Okay. Thank you, Council.
Thank you, and thank you to Mr. McDonnell and Mr. Rackman for that overview and scene setting. As the panel has already read our legal submissions, I don't propose to read them out. And I just wanted to touch on a number of matters to emphasise some of the points from our written submissions and to respond to legal submissions filed by some of the submitters. The panel is well aware that this hearing stream includes additional procedural complexity, given it incorporates provisions and submissions from the original PDP process, as well as the Council's intensification planning instrument. In particular, hearing stream 7 includes the residential, commercial and mixed-use zones of the PDP. PC 19, which, as Mr. McDonnell has explained, relates to the Plimmerton Farm Zone, and that was originally excluded from the PDP as Plan Change 18 was determined not long before the notification of the PDP. The Council adjusted its PDP hearing schedule to align the matters that were originally assigned to hearing stream 7, as well as incorporating the IPI, and that was due to the fact that there was significant overlap between those topics, and it was considered important that those topics be heard together. Although we acknowledge the potential procedural difficulties that hearing parts of the PDP and IPI together in this hearing stream may create, overall, it is submitted that taking this approach will better enable the parties and the panel to consider the planning framework as an integrated whole. And ultimately, this should result in a better strategic planning outcome. Related to this, we note that although parts of Hearing Stream 7 are the Council's IPI and are subject to additional legislative tests and requirements, all of the provisions that the panel is considering need to be considered within the context of the RMA as a whole. And the requirements in that regard are set out in Appendix A of our legal submissions, and we are sure that the panel is well aware of those, so we don't intend to go through them in any great detail. We do wish to acknowledge the work of the Council officers in preparing their comprehensive Section 32 and 42A reports, which provide significant analysis in support of the position that the Council is taking. In relation to the IPI, the Council has considered the additional statutory requirements that apply and has also addressed the broader RMA framework. The intention behind the approach the Council has taken in bringing the IPI into Hearing 7 and through its substantive consideration of the provisions now being considered by the panel has been to achieve that integrated approach. Considering the scope of the IPI, from the outset, we wish to acknowledge the importance of Section 80E of the RMA. In our submission, that provision informs scope. It is clear that the principal focus of the IPI are the matters we have referred to in our submissions as the mandatory outcomes, and these are the requirements to incorporate the MDRS into the plan and to give effect to Policy 3 of the National Policy Statement for Urban Development. We acknowledge that Section 80E does provide for related provisions to be included within the IPI, and this is on the proviso that they support or are consequential on the implementation of one of those mandatory outcomes. This proviso is, in our submission, constraining, and we submit that related is given meaning by its surroundings, in other words, the reference within the legislation to support or consequential. The consequence of this is that it is not the case that any potentially related provision is considered to be within scope. We submit that to be within scope, there needs to be a particular relationship of the proposed provision or matter with one of those mandatory outcomes. In terms of procedure, in considering the matters before it in hearing stream 7, the panel will need to address whether it is making a decision on a PDP submission or a recommendation on an IPI submission. And again, we just wish to acknowledge the work of the council team in preparing their Section 42A reports and the approach they have taken to identifying submissions as being either on the PDP or the IPI. And primarily that was set out in the tables that were attached to the 42A reports. The importance of the panel making a distinction is to ensure that it is clear to the council the matters that it needs to make final decisions on, and it is also important to submitters as there are no appeal rights attaching to the decisions made on submissions on the IPI, and that lack of appeal right is also why it is important for there to be clarity around scope and the matters that the panel is making a recommendation on versus a decision on the PDP. Just turning to qualifying matters under the IPI, qualifying matters are submitted to be an important consideration for the panel as they allow a lesser form of density to be incorporated where particular criteria are met. The approach the council has taken to qualifying matters is broadly explained in Section 5 of our submissions and is discussed in detail in the council's Section 32 reports. I note that Kāinga Ora has challenged the approach the council has taken to qualifying matters, particularly in relation to shading and height controls in areas adjacent to heritage items and sites of significance to Māori. In response, the council disagrees with Kāinga Ora's position that shading should not be a qualifying matter. The council considers that this matter fits within the catch-all in Section 77I subsection J, and that it has been justified in accordance with the requirements of Section 77L. The justification is set out in the Section 32 report and is discussed further at Section 7.18 of the overarching Section 42A report. Or did you have a question, Commissioner?
Are you going off qualifying matters now onto a new topic?
No, continuing on qualifying matters. Although shading may be considered in the MDRS, the proposed additional shading controls have been specifically considered within the context of the particular sites they have been imposed on. These controls are submitted as assisting the council in achieving a well-functioning urban environment as required by Objective 1 of the MPS-UD. The height controls on areas adjacent to heritage items and sites of significance to Māori are clearly possible to be the subject of a qualifying matter as they are considered to be Section 6 matters. Again, significant justification is set out in the council's reports. We submit that it is relevant to consider these additional controls within the review of the wider planning framework that applies to heritage items and sites of significance to Māori.
Question for you rising out of that is the section is protection of the adjacent or the effects of actions on the adjacent site a Section 6 matter, or does Section 6 focus solely on the heritage site itself?
Well, it's the protection of the heritage site from inappropriate development, and in this instance, the council has considered that and has made a planning assessment that those height limits are considered to be inappropriate.
Thank you.
Moving on to the scope of submissions, and I don't wish to labour the point here, as I'm aware that the panel is. Many of the panel members are involved in other IPI hearings, and also we have set out some specific scope matters.
But before you move on to scope, I do have some questions on qualifying
Sure.
matters. So, first one is this. You quite usually list the sections of the Intensification Act that sets out the list of qualifying matters and what the council needs to do to prepare supporting evaluation reports. There's equivalent provisions of those in the MPSUD also, particularly around 3.32 and 3.33. Are they largely interchangeable? Are those provisions in the MPSUD and the legislation interchangeable, or should we be relying on the wording in one over the other?
I would be relying on the wording within the RMA itself. As I understand it, they are very similar.
Yes.
I'm not 100% sure if they are 100% identical, though.
Okay, just that I've relied largely on the wording of the MPSUD. It's a document that I'll have in front of me, but
Right.
I just wanted to make sure I wasn't creating a major legal issue in doing that.
I would always go to the primary piece of legislation, and so we can certainly confirm whether they are identical or not.
Okay.
But as I understand it, they largely replicate each other.
Yes. Okay, so I've got. Do you want to come in?
The thought that goes to me is that to the extent that they are different, the legislation would have to contradict what's in the NPS to meet the king salmon tests. If they were additional, you'd have to meet them both, wouldn't you?
Can you repeat that point, sir?
You have two sets of one in legislation and one in the MPSUD that are similar but possibly not identical. As Mr. suggested, that we'd always go to the legislation, which is of course correct. The rationale or the authority for that is clearly king salmon that says if something in a higher order document is quote illegal, then you can disregard it and not follow it. So if they're to the extent that the legislation contradicts what's in the NPS, then the legislation prevails. But if it's not a question of contradiction, if it's a question of addition, the MPSUD adds something additional, then you would have to comply with them both. We would have to give effect to them both, wouldn't we?
Well, yes, I think you would. The hierarchy would work so that the legislation would sit at the top, and then the national policy statement would be expected to align with that. But I think here the context is going to be important, and we might need to look at the framing of 3.32 in the MPSUD versus section 77L, because, I mean, looking at the MPS wording now, 332 clause 1 reads, in this national policy statement, qualifying matter means, and then you've got A through H.
Yes.
So that definition is specific to the way it's used, qualifying matter, in the MPSUD. The provisions in the Resource Management Act were included for the purpose of informing what goes into your IPI and is then considered through ISPP. So I think context matters as well. We're not perhaps dealing with a definition in the RMA itself that is intended to apply in the same way as the MPSUD, but some further work to triage that will probably need to be required.
Okay.
So the key question is, how exactly are they different? I wonder if we could ask you, the first thing on the list of things for you to report back is to give us a a red line or a markup version starting from the legislation, identifying where and how the NPSUD is different, and then doing the same in the opposite direction. Because I imagine that if there are slight differences in wording, it might get a bit difficult to understand. But you understand what we're asking for, what I'm asking you for.
Yes, absolutely.
Okay, with that as basis, I've got 2 or 3 specific questions on qualifying matters and their application. The first is, and let's assume there's not any substantive difference between the legislation. With the qualifying matters that are listed in 332, Roman 1A to G, which are, I guess, the mandatory qualifying matters, if you like, for want of a better term, versus the discretionary one in H. Is there any difference in, well, let me rephrase that. Presumably the matters in A to G are qualifying matters by right. They qualify as qualifying matters, but they still need to be tested and applied in a specific instance. The mere fact that they're qualifying doesn't, without any analysis, doesn't create a qualification in its own right, does it?
I agree that there does need to be a further analysis to
Yes.
determine the appropriate way to provide for those qualifying matters. So it's certainly a starting point for the council to undertake its planning analysis.
Yes, and 333 of the MPS requires an evaluation report to be produced
Yes.
under Section 32 in relation to those matters. And then Clause 3 of that section says the matter is not a qualifying matter under 32.1H, which is that discretionary matter, unless the evaluation report also does a number of things, identifies the specific characteristics, and then does a site-specific analysis. So my question there is there a different level of analysis required between the matters that are in A to G compared to the matters that are in H?
Yes, there is, and that is a similar requirement is provided for in the RMA provisions as
Okay.
well around section, I think it's section 77L. There is an additional level of analysis that is required for what we have termed the catch-all qualifying matter,
Yes, let's call it that. Yep.
which enables the council to consider other matters which it has determined to be of importance and should be used as a basis for changing the density standards.
Yes.
And there is that additional obligation to meet those requirements in its evaluation report.
How would you categorise the nature of that difference between the A to G matters and the catch-all in H in terms of the level of analysis required?
I think as you have identified, those other matters sort of are qualifying matters by right. And so there is that requirement that you need to provide more site-specific analysis, additional characteristics. You know, it is far more, it's intended to provide far more in-depth analysis of the particular matter and how it is to affect the density requirements and why.
Does that mean there's no need for a site-by-site analysis in the mandatory or the ones that qualify automatically? I mean, Clause 3 under the catch-all uses the term site-specific analysis. I can't see that term used in Clause 2.
No, the reference in 3.33 is to the area. So the 32 evaluation needs to demonstrate why the council considers the area as subject to a qualifying matter. So it's intentionally broader than the reference to site-specific.
Okay.
And then also demonstrate incompatibility between the level of development directed by Policy 3 and that particular qualifying matter.
Yes. So what's the term area referring to? What in this context?
Well, you would assume it's the area that's affected by the qualifying matter that the council's relying on
Okay.
to not deliver that degree of intensification. And the council officers will be best placed to answer this question perhaps on how they have approached that analysis.
Okay. No, that's fine. I think I understand that. The last question I've got is in relation to the discussion I had with Mr. Racklin about, and I think you did use the word, what was the term? Well-functioning qualifying matter. I just parroted it back, Mr. Racklin. It's probably a shared responsibility there. But I just wondered where those local centre qualifying matters that Mr. Racklin referred to, where are they derived? How do they fit into that categorisation?
As I understand it, and Mr. Racklin can correct me if I'm wrong on this, that has formed part of the council's understanding of what a walkable catchment is.
Yeah, no, I understand that, but
I wonder if there are qualifying matters at all, given
Yes.
that they're enlarging.
They're enlarging.
They're more lenient than a qualifying matter is something that is reducing density, whereas there's a general discretion, Commissioner, to be more lenient based on the objectives and policies of the NPSUD.
yes, and I guess if there's any leniency, it's in defining what the walkable catchment is in terms of its dimension. So I think you agreed, Mr. Racklin, that those local centre brown dotted lines that you come from policy 3D, which is the discretionary policy that the council has in relation to local centres.
The 3D described it as being discretionary.
Well, it's commensurate. Sorry, let's call it the commensurate policy. That
'cause
with
it
and
is-
adjacent to local centres, building heights and densities form commensurate with the level of commercial activity and community services. So you've obviously identified those areas that allow intensification.
Maybe the discretion is choosing 5 stories as opposed to 6,
6.
as opposed to 4 or whatever.
Yeah, so we did take 3D, and that's how we applied it, was to say that these local centres have either or will provide a range of services, and so they are appropriate places to enable further development
Yes.
over and above the MDRS.
And you've chosen 5 at 5 verse 6, and I wasn't was it 400 or 800? I wasn't too sure.
So there's so the number of metrics that overlay each other, if you like. So the primary metric is the 800 metres from a local centre. Then we overlay that with, do these areas have access to a local park?
Yes.
And that's the metric of 400 metres. And then there's the access to primary school,
Yes.
which I believe was 1,000 metres used to define that in terms of achieving an accessibility level to those 2 factors. And they were chosen together with supermarkets for the high density one, because we believe they're necessary to achieve the overall objectives of the NPSUD in terms of things such as accessibility to services and facilities, support and reduction in greenhouse gases, so that people can actually genuinely walk or access these facilities and not rely on or embed current car use. So it's a range of factors that we've used to define a walkable catchment in a way that we believe is necessary to achieve the objectives of the NPSUD. And so in terms of the local centres, the 5 stories or 18 metres, because we don't think they should be intensified as much as a high density zone where you're talking 22 metres or 6 stories. But clearly we need to signal that they're going to be, the intention is to intensify more than just the MDRS. So it sits in between the two. And so the 5-story was the one that we felt would reflect the way that these local centres can support a level of intensification in a way that overall meets those objectives.
Okay, I understand that. I mean, at the appropriate time, it might be useful for you to take us through a case study where you've applied the 800 metres, overlaid the 400 parks, the 1,000 metres for primary school, and just to show how that line is being nuanced in a particular case or cases.
Yeah, I'll probably need to, I might need to pull in one of our GIS
Yeah.
people because there's
That's fine.
numerous layers that we have to sort of bring up to do that. But yes, I will, when I get an opportunity, I'll go and speak to them.
Thank you. Thank you, Ms. Fitzwick.
So, moving on to scope of submissions, we have set out a table at Appendix 2 of our submissions, which sets out particular matters relating to scope. And broadly, we consider that the usual tests for scope should apply for determining whether there is scope for a submission. And those tests are set out at 6.4 of our written submissions. And I note that there appears to be agreement with Greater Wellington Regional Council on this point around the appropriate tests that should be used, and no other submitters have contended that a different approach to scope should apply. When determining whether a submission point addresses the IPI, the panel will need to consider whether the submission point implements the mandatory outcomes or can properly be characterised as a related provision to a mandatory outcome. When considering related provisions potentially being sought by a submitter, we consider that there needs to be a connection with a mandatory outcome, as we've discussed earlier. We note that many of the concerns regarding scope raised on the submissions on the IPI come from submitters not providing sufficient particulars in their submissions to identify the connection between the relief sought and the mandatory outcome. So it may be that some of those scope issues resolve themselves through the provision of further information to the panel. And finally, just to conclude, there are a couple of matters raised in the legal submissions from submitters that we just wish to touch on. The matters raised in submissions are considered to largely be addressed by the Council through its Section 32 and 42A reports and in our written submissions. We acknowledge that some differences in planning opinion appear to remain, though. However, we note that we don't agree with the approach that the Retirement Villages Association and Ryman Healthcare appears to have taken in its submission. While the submission itself acknowledges that the interest of these parties is unsurprisingly in relation to retirement villages in the relevant zones, and not general residential activities, the submissions seem to be seeking far broader enablement of additional housing capacity. As discussed in our submissions from paragraph 9.8, the approach the Council has taken to enable development capacity through the PDP and the IPI process more than meets the housing bottom lines incorporated into the regional policy statement. In fact, I think the enablement is more than double the housing capacity that the RPS requires. It is difficult, therefore, to see how the approach taken by the Council is the bare minimum to meet the requirements of the NPSUD, as appears to be stated in the Retirement Villages Association and Ryman submissions. Furthermore, the Council's approach has been to incorporate and give effect to the mandatory outcomes in a way that considers the NPSUD as a whole and within the broader context of the RMA. Finally, just touching on the Radio New Zealand submissions, I note that Mr. Rory Smeaton has considered the agreements reached during the conferencing, which occurred late last week, and is drafting updated provisions relating to the proposed qualifying matter in relation to Radio New Zealand's transmission tower.
Thank you, Ms. Squidge. Can I take you back and ask you more generally about the relationship between the variation and the PDP? Are there any non-IPI provisions in the variation or PC19? Is everything in it?
No, I understand there are some non-IPI provisions.
And how are they identified?
The provisions themselves, I don't know, are specifically identified. The focus has definitely been on the submissions and the submission points that the panel will need to consider.
Well, that's going to be a problem for us because one of the things in our recommendations, we have to specifically identify the IPI matters. So, and maybe, okay, so that's the next request. If Mr. Racklin can help, then that's fine.
If I understand what you're looking for, it was something we put into the section 32. If I believe, if I recall, it's a requirement, although it doesn't have to go into the plan, it's a requirement to identify what all the provisions are that are subject to the IPI. And so should be, I'll just check the appendix, which lists all the provisions that we consider to be within the IPI. So I don't know whether that's perhaps what you're looking for in that sense.
So the first question might be, if you could, I was going to say ask us just to give us a reference, but it might be more helpful if you could print out a copy of that appendix for us. Next leading question that's fresh in my mind. Is there anyone seeking that matters identified by the council as IPI matters be treated as first schedule matters or vice versa?
Not to our knowledge. Just going back to the
Possibly a good thing.
yes, appreciate the chair's involvement in other processes where that has some complexity. Just going back to the earlier point, though, even though some provisions may be considered to be within the IPI, where there is a submission from the PDP on those provisions, we consider that the panel needs to make a decision on that submission.
Yeah, like they're deemed to be on the variation, but the next question will be, are they deemed to be on the part of the variation in the IPI or the part that's not?
And we consider that those original submission points still do retain their appeal rights. We don't consider that.
I'll come to that because I understand your reasoning, but if they're deemed to be on the variation and they're deemed to be on a part of the variation that's in the IPI, how can they be deemed to be part of the IPI for some purposes but not for others?
I think they are deemed to be on the IPI so that they can be considered as it wouldn't make sense to split your reasoning between the PDP provisions and then the IPI provisions because they are, in many respects, the same provisions. However, we struggle to see how where legislation that is subsequently introduced after someone has made a submission on a particular process, which has an appeal right attached to it. Legislation is subsequently introduced which changes that process essentially, but there's no express statement within the RMA that says that those original submissions lose their appeal rights. We do appreciate that any such appeal may struggle on a merits argument, and so the wisdom of bringing such an appeal is potentially questionable, but that's not for us to determine.
Yes, I can bear with some equanimity the prospect of the Environment Court wrestling with those issues. So you're resting in effect on broader constitutional grounds that it can't, in effect, retrospectively remove appeal rights that a submitter originally have. Like, that's paraphrasing my understanding where you're coming from.
Yes, essentially we consider that it raises some substantial questions around natural justice.
The question of what is supporting and consequential on the MDRS, how do you define support in that context?
It needs to assist in giving effect to those requirements.
Is a qualifying matter reducing heights supporting the MDRS or not?
It's supporting giving effect to the MDRS in a broader context, but within a broader planning context. But then there is also statutory provision for a qualifying matter as well.
But the way that statute works is that it inserts that whole range of 80E2 back into 80E1C, I think it is. It says in deciding what a related matter, this is my recollection, in deciding what related matters for the purposes of 80E1C, you can have regard to the following, or you can include the following matters. But they're not standalone saying, it still says these are related. The matters of, so do we still have to decide, for instance, that a qualifying matter is supporting or consequential on the MDRS?
I think it probably falls within matters that are consequential on the implementation of the mandatory outcomes, because without implementing the mandatory outcomes, you wouldn't need to go through this process of identifying qualifying matters. So it's consequential on the implementation of the mandatory outcomes when considering the obligations and the RMA as a whole. And then I suppose the provisions relating to qualifying matters then provide clear guidance as to matters that can be consequential to those mandatory outcomes.
Okay, I'll come back to that. The in terms of your 3.7, there's a spatial aspect. Yes, I understand that. Related needs would need to relate to an urban environment. Is that an urban environment as defined by the PDP or as sought in submissions?
It's probably both. If the panel is minded to extend the urban environment as sought by submissions, then it would include that additional land.
So the sort of, if we accept the submission on the merits, then it will be urban land, therefore it will be the IPI. It'll work back that way.
Yes.
An example of that is one submitter, I think it might be Kaingaroa, have sought extensions to MRZ and HTZ, which in turn, if accepted, would push out the walkable catchments. And then
But that's still within the urban environment.
It still
I'm
is.
thinking more of Silverwood that's seeking to rezone rural land.
so it'd be yes. Okay, yeah. Quite a difference.
Yeah.
Is there anything helpful in the legislation about the actual interface between urban and rural, since it just says it's either, appears just to read, it's either urban or rural? What about the interface between the two? And if you've got situations where they're changing, is there anything in there that addresses that matter?
Look, not specifically, but I do think
I think not helpfully might be the...
well, I was hoping you'd leave your question at, is there anything helpful in the legislation? But you do
Yeah.
continue. No, not specifically. This legislation and this IPI process is directed at your relevant residential zones within an urban environment. I think that's the point that's made in the submissions. But then there is the ability through 80E1B to amend or include following provisions, related provisions, which could capture district-wide matters. Now, that's where there is this potential gateway, and looking at your provisions that affect land immediately outside your urban environment to the extent that they might need to be looked at. But there is a line to be drawn somewhere where you get too far rural and you can't rely on that related provisions clause. And that's the approach that the council office will be able to talk you through. That there has been an exercise to look at the land immediately outside and the extent to which some district-wide provisions, stormwater flooding and those types of things might require some review. But there's nothing that clearly expresses that barrier, boundary.
So that this to the related provisions, is that provisions as in anything within the plan, or is it provisions as in the Section 32 context of objectives aren't provisions, provisions are policies and rules?
You need to look at Section 80E2. There's an inclusive clause there which tells you what is captured within your related provisions. That's not a definition of what's related, it's an inclusive list only. But outside of that provision, to my mind, there's nothing that clarifies that point any further.
Going to 4.17, 42A reports identify the processes relevant to each submission. Can you give me an example, show me where and how they've qualified? I'm happy if you pass that over to the officers who wrote those reports, because I was trying to find an example so I knew what I was looking for.
So what the 42A reports have done is attach tables which identify the submission points as being either on the IPI or on the PDP.
I've just opened at random the first page of Appendix B to the overarching report, and there's a column, submission reference, submitter, provision, decision, section of the report where it's discussed, the recommendation, the reasons, amend PDP, yes or no.
I think the tables are split. Is that correct?
Correct. So the tables are split into table B1 and B2. So
So that's the difference. So there's a
B1's
separate,
B1's completely submissions received on variation 1, so they're obviously on,
which is why I was getting puzzled.
yeah.
Thank you. So B1 is IPI, B2 is PDP.
In the overarching report, yes, the order might be swapped over in some of the other 42A reports.
But
Apologies for
that's how it's
consistency.
done.
Yeah, that it is split though, in each
Right.
report.
Sorry,
4.22,
4 point,
you're before then?
well, just before you get there, 4.21, the tests are about, talking about application of clear water and motor machinists. In terms of how you've classified, like I'll look at this when I look at that schedule of the 32 report. So, for instance, the JIS, quite minimal changes in the variation to the text. As a point of principle, if the variation hasn't changed a policy of the general industrial zone, to your mind, is it still a first schedule matter?
I would, in my view, particularly for something like the JIS, where if the objectives weren't amended either or in a meaningful way, then I would say that the downstream provisions from there would be outside.
And next question is a point of principle. You have a policy that could have 15 subparts. The variation amends one of the subparts. Is the balance of the policy still a first schedule matter, or is it because the variation has amended part of the policy, could be a small part, could be a large part, then the whole policy is classified as an IPA matter?
Now, certainly something had to grapple with in terms of were the changes purely mechanical in terms of changing the language. So instead of saying character and amenity, we said planned urban built form or built environment to update the language, but the intent and nature of the policy did not change, or the provision did not change. So where I can, I have tried to address that, the degree of change and how that then has knock-on effects. So where the policy intent has not changed, it's just more of a language change, then there could be the view taken, well, it's still technically a PDP thing because you've not changed the intent of it. The only thing I would suggest on this is the approach we took in terms of amending the commercial chapters was to, because MDRS Objective 1 needed to be incorporated into the plan, that talks about a well-functioning urban environment. If we then turn to the MPSUD to look at what is that, one of the factors, I think it's Objective 3, talks about more people are able to work in certain locations. So we've taken the view that we, under the IPR, we could amend the regulatory framework for land use distribution to achieve the outcomes of the MPSUD. So it's not just about building up, it's about increasing employment opportunities in certain locations because of the fact that the MDRS Objective 1 has been incorporated into the plan and then has this flow-on effects downstream. So that makes things, I suppose, a little bit more complicated in the sense that I would argue that you can look at it through that lens of saying, well, it's broader in terms of giving effect to the MDRS itself, which is not just the building heights, but this policy objective context.
Thank you for that. So that's emphasising to me just how complicated that decision is on a provision by provision basis, and there are thousands of provisions that you've made that call on.
Yes, that's very much what we had to grapple with in terms of the trying to implement this legislation.
Yes, well, residual bow in the general direction of MFE at this point. Going, Ms. Viskovich, to your paragraph 6.11, you said there needs to be a link consequential on, sports consequential on, needs a link. So my question is around, is it more than just a link? Like, consequential suggests to me a need to ask the question as to whether the change would have been required anyway. If it would have been required anyway, it's not consequential.
I think, though, if there is some connection between the proposed amendment and those mandatory outcomes, then I think there is still scope for it within Section 80E. Just because something might have needed to have been fixed anyway doesn't mean that it isn't supporting or consequential to implementing those mandatory outcomes.
But I'm thinking like flood hazards, the extra flood hazard maps would have applied equally to the general residential zone. The fact that the area is floodplain and that those flooding areas need to be identified isn't something that's consequential on the MDRS. Maybe you could argue that the MDRS increases the risk because the consequence is greater, but that's, are you down to that kind of analysis?
I think there is a link between implementing the mandatory outcomes and as you have pointed out, by doing so, that flood risk is exacerbated. And so there is a need to include that flood mapping within the plan, and this seemed to be an appropriate avenue for doing so.
Yeah. That's consistent with what you say at 5.4 on page 15. We say that inclusion of the flood hazard overlay in these areas supports and is consequential to the implementation of the mandatory outcomes.
Aside from the fact that the language is wrong, it's not consequential too.
I don't have a question there other than to indicate, I guess, to the officers that it would be very useful to understand the philosophy behind the application of qualifying matters as qualifying matters and the application of them as overlays and how that's been distinguished. So maybe later in the week for that.
6.19.
Could I go backwards?
Go for it.
Thank you. 5.1, the paragraph just at the bottom there, require management in a different manner from underlying zone provisions. So, do you mean just the zoning provisions, or are you underlying zone in relation to a designation?
We just
Or is
mean
it
that just the
zoning
zone provisions, just the zone.
You ask the leading question of whether we have any other issues about scope. The obvious one is the evidence we received Friday. We're yet to see Mr. Dawson's legal submissions. I asked Mr. Dawson specifically to address us on whether Silverwood's requested relief, not the relief, repeating the relief it made and we were heard in Stream 5, but seeking a live zone, is that on the variation? And if you want time to think about it, that's fine, but I want to put that on the table. That is something that we need to know what the council's opinion is. As I've already fired across a shot across Mr. Dawson's bows, that certainly in my mind is an obvious question, given that you're seeking to rezone rural land to an urban use, and the variation only relates to urban land. So can I just leave that with you?
Yes, well, I think we will respond to that more formally if it pleases the panel.
That's in the same category. We need to know your answer by next Wednesday.
Sure.
And you're in relation to the discussion of Ngāti Tawa 7.4, Council is the responsible planning authority, doesn't have the power to carve out areas of the district where the district plan will not apply. And I thought to myself, isn't that exactly what you've done with Plymouth Farm?
Except there is a planning framework that does apply in Plymouth Farm because the ODP provisions were always intended to continue to regulate the Plymouth Farm zone. The PDP was a full plan review with the exception of one greyed out site, which was the Plymouth Farm site.
Is that a potential approach in response to the Ngāti Tawa submission?
As I understand it, they are seeking something different. I don't think that they want the ODP provisions to continue to apply. They are seeking an overlay, and where the council has struggled is exactly how that would operate until Ngāti Tawa is able to spatially define what that land actually is, that settlement area.
Go, Mary.
Kia ora. Just a follow-up question on that one. It's a really interesting issue, and I understand your point about the jurisdictional and logistical difficulties in dealing with it, and in implementing an overlay for a Ngāti Tawa zone that is specifically designed for treaty settlement redress lands. But you do go on to say at 7.6 that the council may, however, have jurisdiction to include an overlay across the relevant land if it can be demonstrated that such an overlay directly relates to one of the mandatory outcomes. Now, taking section 6E as a mandatory outcome, which provides for recognition and provision for the traditional relationship of Ngāti Tawa, in this case with their ancestral lands, would, in your view, would land returned to Ngāti Tawa via a treaty settlement not be adequate, not provide adequate demonstration, if you like, of the iwi's ancestral connection to it?
In principle, yes, I think that you're right, that it would. I think where the council has struggled with this particular submission point is just understanding exactly what is sought, the particulars of it. And so it's certainly open to considering something, but the issue that it has had is that it hasn't been able to engage fully with the submitter. Mr. McDonnell may be able to update the panel, but I understand that you were trying to meet with Ngāti Tawa to discuss this particular matter.
Yeah, that's correct. I've made a number of attempts to arrange a hui on this matter, but it's been difficult over the summer break. I did manage this week to catch up with the staff from the Runanga who will be presenting to the panel later this week or whenever they're presenting. They indicated that, so this is covered in section 7.4 of my overarching 42A.
Yes.
They indicated that they're not satisfied with my recommended approach to that's outlined in my 42A report. And we briefly discussed their submission point, and I said it's I consider it to be quite a high level submission point. It's a zone that isn't provided for in the planning standards, where the submit is seeking uninhibited tino rangatiratanga in that zone. So my question was, and this is outlined in my 42A report, where are these sites, exactly what zone or overlay is applicable, what's the resource management approach in that zone, what objectives and provisions should apply, where's the evidence base to support that. So it may be that the submitter turns up, and I know they haven't filed any expert evidence, but it may be that they speak to that submission point, and
Thank you very much. I'll follow that up at the time with further questions. Hilda?
Question might be, could it be an overlay with literally no provisions, and leaving the matter left on the basis of the Section 9 presumption that if there are no provisions restricting land use, there are no restrictions?
I mean, this is all the detail I'd need to work through, depending on what was sought, because council does have a responsibility to have a district plan and to apply national and regional direction to that land. So, and of course that would have to be balanced up with Section 6E of the RMA. Would also have to consider that some of the land is currently not owned by Ngāti Toa, and may never be, and likewise some of the land might be owned in the future by Ngāti Toa but unsold. So there's a fair bit from my planning perspective. There's a fair bit to work through from what is a relatively high level submission point, let alone the requirements of Section 77I and J. If those provisions were to amend the MDRS in some way, then there'll be additional evaluation requirements as well.
We don't have any evaluation of those either. Commissioner Sinclair?
622 and 623 of the legal submissions there. So with precincts A and B, as I understand it, because they're subject to the IPI, we can change those if the mapping
Yes.
correct. But equally, if the mapping's incorrect in C, we can't change that because that's not part of the IPI, right?
Yes, that.
And so the fact that they're not precincts B and C, at least the interface between them is not correct, potentially, so therefore we can't change it.
I'm not sure that I understand the question. What do you mean by the interface?
Well,
because I understand
where
sorry.
B and C, if you look at the original plans, may actually overlap. So which is it?
Do you mean that
you're
the
saying
overlap, the two precincts overlap?
Yeah,
It's not
well, they don't. The two precincts are shown on an earlier plan as being in a different location to what the ones are they're shown now. So if there's if they overlap like this, under one of them it's B, and another one it's C. So depending on which one of those is correct, if that was corrected, then does the IPI provisions providing it, I suppose, changed it to urban, would that mean that it was within our jurisdiction to correct the error?
My understanding is that the issue that's being raised by KM and MG Holdings is in relation to the biodiversity areas, not necessarily in relation to the boundaries between precincts B and C. So therefore, I think you can take the boundary between B and C to be that shown within the operative district plan, where we do consider that there is a scope issue is in relation to the removal of those BORA areas, biodiversity offsetting areas within precinct C. We don't consider that precinct C is a relevant residential zone for the purposes of the RMA, and so therefore is not part of the IPI.
it's just not part of it, and therefore, because it, what is it, PC 19 only relates to the IPI provisions.
Correct. It only relates to precincts A and B. And to date, I mean, we appreciate that there may be mapping errors that have crept in, but we, although I understand Mr McDonnell does not support the removal of the Bora areas.
I think that's for a different reason, though.
And but that's
Yeah,
but
that's
that,
not a
I guess-
jurisdictional.
Sorry, and it's not actually within our jurisdiction or therefore before us.
In terms of precinct C, no.
No.
We
So,
don't
and
consider that
to
there
get
is.
this right, that another plan change is required to have the Plimmerton Farms area brought into the current planning framework.
Yes, and I think that's another issue separate from the Bora. I think there you're referring to bringing the Plimmerton Farm Zone across to fall more
Be part of
comprehensively
the
as part of
whole plan, yeah.
the whole plan. Yes.
I take it one of the officers will be able to tell us why that hasn't already been done.
Yeah, it's addressed in the Section 32A report. I'm just scrolling through trying to find a reference. Hang on, I will find that first. It's covered in Section 3.6 of the Section 32 report for Plan Change 19. So basically, Plan Change 18 was notified on the 20th of May 2020, and which was after the release of the first national planning standards. The Plimmerton Farm Zone only partially aligned with the planning standards. And this is because the plan change was to the operative district plan. So the scope of the plan change didn't include a overhaul of the operative district plan to align with the planning standards. So it was a standalone bespoke plan change for one site. That was on a separate track to the proposed district plan, which was notified soon after that. So they kind of took two different paths, but it was not proposed to bring the zone into the proposed district plan through plan change through variation 1, I guess, because one of the main reasons is the Plimmerton Farm Zone has a number of unresolved issues that a consenting process needs to address. So there's a lot of spatial elements that are not mapped yet. So the extent of wetlands, the extent of a proposed commercial centre. So council's view was it was best for that kind of front-loaded consent process to identify these areas, and then they could be at a later date within the time frame allowed for to give effect to the national planning standards brought into the PDP. So the intention is for council to do a further plan change to the PDP to bring it in once some of those spatial extents are known and mapped, and we can assign them a zone under the national planning standards and bring it in. And keeping in mind that it will need to fully integrate it. It's not as simple as stapling the zone to the back of our plan. It needs to, all of the definitions will apply. There will need to be planning analysis to bring the zone into the PDP. Sorry, that's a long answer, but did that answer your question? Or?
I just make an observation that it appears that the consenting process is driving the plan process in that regard then.
It's timing-wise, it is, yes.
Wasn't.
I have one question left, Council, but it's rather a large question. So I think we'll take the break and come back at 10 to 11. hearing. Council, the sole question that I have left for you relates to walkable catchments. And I'm trying to understand the council's logic and your logic supporting what the council's done with reference to policy 3C. Now, what I understand the council has done, as Mr. Racklin summarised it, is that it's defined an 800-metre walkable catchment as a starting point, and then applied secondary considerations about walkability to schools, supermarkets, parks. The question I have for you as council is whether that approach complies with policy 3C of the NPSUD, which says intensification must be allowed of at least 6 storeys within at least a walkable catchment of, in this case, existing rapid transit stops. And the issue I have in my mind is that that's asking about what is the walkable catchment from the train station. It's not asking what would be a walkable catchment from, for instance, a park. Does the distance to a park affect walkability to the train station? And I'm struggling to see how it does. Or put another way, for Parramatta, what walkable catchment has the plan defined?
So, in terms of the approach to walkable catchments, the term isn't defined in the NPSUD, and so, as you have just pointed out, the council started with the position of an 800 metre, and Mr. Racklin can correct me if I'm incorrect on in any of this. So started with the 800 metre walking distance from the train station, but then also in order to consider and include within the walkable catchment, it's taken a more holistic view and hasn't just applied that. It's tried to achieve a well-functioning urban environment and considered the NPSUD more holistically, and so has also prescribed those additional criteria which you've just talked about, the primary schools, supermarkets and parks, because essentially, I mean, if you think about Porirua Bay, it seems quite inappropriate to have 6-storey buildings out there. And so the council has attempted to take a real world view to determining what it considers a walkable catchment to be. And it's submitted that better achieves the NPSUD as a whole. We don't consider that it's appropriate to just read policy 3C in a complete silo.
No, and clearly you could cite to me tomes about the need for a purposive approach, starting with the Interpretation Act and going from there. But there's a difference between interpreting and rewriting. And the NPS asks, what is a walkable catchment of, in this case, a rapid transit stop? Does the fact that there's no school mean that it's not walkable to the rapid transit stop? Like, Mr. Wayfield, I'm happy for either of you to answer. You don't need to swap notes. Like this is going to be really critical. Like, I understand exactly what you mean about a real-world approach. What I'm going to say to Mr. Whittington, if he's listening, is that it strains credibility to conceive of 6-storey apartments in downtown Porirua Bay. A certain suspension of disbelief is required. But we have this mandatory direction in the NPS. Are you saying that the NPS direction is absurd in this particular say? Is that where the interpretive link goes? Say, how do you interpret those words to authorise what the council has done?
And I think the distinction perhaps is that policy 3C doesn't just say walkable distance from. It talks about a walkable catchment, which the council has interpreted as engaging a broader set of considerations. And it's the catchment that needs to be serviced by the rapid transit stop. And in this case, it's the catchment that could be appropriate to benefit from the additional intensification that this policy is contemplating. And I completely understand the issue that you're grappling with here, where you've got what appears at face value to be a fairly blunt direction. But the term catchment is considered to be significant here, and it's what the council has referenced when driving and forming criteria against which it's considered how to give effect to Policy 3 across its urban environment. Now, the real world view, of course, is one thing. The proper interpretation and application of policies is another. But here there's a cross-section or an emerging issue that arises when you try and do both. And the officers, of course, have approached it through the holistic view that well-functioning urban environment requires well-functioning catchments. And in this case, Porirua Bay isn't one of those that's going to appropriately benefit from 6 stories.
I can't remember if he's done it yet, but I'm sure that Mr. Whittington would respond and suggest to you that the word catchment is just a synonym for the circle that you draw around, in this case, a rapid transit stop, and that it's straining any rules of interpretation to interpret it any other way. That's, as I say, if he wasn't planning on saying it before, I suspect he certainly is now. But what would be your answer to that?
I would probably give him some credit for that argument, sir. But equally, there is a need here to also make decisions that accord with the relevant statutory framework, and Policy 1 is also in play alongside Policy 3. And that brings in those broader considerations that also must be satisfied by decisions that this panel is required to make. I don't know that I can take it too much further than that, sir.
Okay. Any other questions for Council? One of the things I will do tonight, Mr. Wakefield and Ms. Viskovich, is I will email Mr. Marshall my notes of the things you're going to provide to us, and if they don't accord with your notes, then you can tell me about it tomorrow, or pass, if you're not going to be here in person, pass a message back through the council staff.
Yes, sir.
Mr. McDonnell, I presume.
Thank you, Mr. Chair. I just have a few short comments to make to kick off the discussion on the overarching 42A, particularly just outlining some points where I am in agreement with submitters, and also some areas where there is still some contention. First of all, I did not provide any rebuttal evidence in response to any evidence we received. So I consider my recommendations on those submission points in the 42A stand. The only expert evidence of real relevance to the submission points I analysed was from Greater Wellington Regional Council, and I'll address this shortly in more detail. Points of agreement, just working logically through the report. Section 7.4 Papakainga. Just wanted to note for the panel the submitter Te Whenua Ora, who submitter 35, who was covered in the addendum, because we omitted to make recommendations on the submission points in the original Section 42A. I understand that they are not appearing to present to their submission points, and I don't believe they've submitted a memo, but there was an email saying that they will defer to the runanga on the matters relating to the definition of papakainga. So you just wanted to note that for the panel, that they're not appearing.
I think that was in their covering email to Mr. Marshall.
Correct,
Because he forwarded it on to us.
I just wanted to note it because it's not, I don't believe it's in the record, the public record.
Right.
Section 7.13, flood mapping. So there appears to be some agreement with several submitters who are not appearing at the hearing. So one is the Church of Jesus Christ of Latter-day Saints, who sought some removal of flood ponding on their property, and based on the recommendations of Mr. Osborne, I agree with the recommendations of Mr. Osborne that ponding was an error. So it appears that the submitter is in agreement with that. And the other one is two submitters, John Sharp and Whitby Lake Villas Body Corp, seeking the removal of flood maps on their properties in the Waiohata Duck Creek catchment. And as I mentioned earlier, we're in agreement with those submitters because the council has resolved to withdraw those flood maps for that entire catchment. And section 7.16 around Plimerton Farm overlays. So this was covered briefly in an earlier hearing stream. The PDP should have basically a black hole where Plimerton Farms is. There were a number of overlays included in error on top of that property.
One was noise, I remember.
There were several, significant natural areas and a special amenity landscape. There's potentially one other, I don't know off the top of my head, but all of those are basically included in error. They should have been clipped out when the maps were uploaded. And so I'm in agreement with submitter Robin Smith there around their removal. And I believe that KM and MG and Plimerton Developments Limited both sought that the Plimerton Farm Zone is included in the PDP as a special purpose zone. I believe, and I was going to double check this, that they've...
You're right. They had that Mr. Winchester's submission saying they're not pursuing that point.
Yeah, correct. I wanted to double check that, but yeah. So I think we're in agreement there that should not be included in the PDP as a special purpose zone. Issues remaining contention is basically everything else. There is the section 7.4 around the introduction of a Ngāti Toa zone. So as I mentioned earlier, there's no expert evidence there, and we've had a brief hui with the runanga, but that's still in contention. A few other topics around consultation, freshwater management. There's still a site-specific flooding issue from a submitter, Alan Collett, who's speaking later in the week around disagreement around the way flood hazards mapped on the property. And there are a number of other submitters around natural hazards. So the EQC have not provided any expert evidence in terms of the relief they're seeking to add liquefaction, landslips and faults to the plan. And I also note that I reviewed the Kainga Ora material expert evidence and legal submissions, and there's no mention of the relief sought to remove the flood maps from the PDP, but I assume that's still an issue in contention. So that's just a quick overview of those. Greater Wellington. So Greater Wellington did submit some expert planning evidence from Pam Guest and Dr. Ian Dorr, and some additional evidence from Stu Farrant on water-sensitive design, and there was some legal submissions. I note that they've picked a small range of issues to give evidence on, very small considered compared to the number of points they made. So there is a lack of evidence around a large number of other submission points, particularly biodiversity, zero carbon infrastructure, assessing and offsetting greenhouse gas emissions and the like. My view is, having reviewed that expert evidence from Greater Wellington, that my recommendations in the Porirua report stand. I believe it's still unclear exactly what is sought by the submitters, even where there have been some provisions proposed, and I'm happy as we work through the Porirua report to talk to some of those issues in more detail around my planning opinion on their relief sought. So with that, it's a quick overview, and happy to take questions on the Porirua report. And
on the last point, I think my plan is I'm going to ask Ms. Guest what her additional provisions mean, and if we get to that point, we might ask you to respond rather than to anticipate what they might say.
yeah, certainly.
Commissioners, it's a long report. As previously, I think my plan is that do it section by section. Anything on section 1? I don't.
Sorry, Mr. Chair. Just a very quick question from me to you, Mr. McMinnell, in relation to the very first page of your report, the introduction section there, and just a quick question, if you could please just provide a really brief explanation of what the cultural advice from Te Rūnanga o Tō Rangatira involved. What was the process? And I'm referring here to paragraph 13 on the first page, where you make a comment about the way in which the recommendations have been evaluated, and they were based partly on cultural advice received from the Rūnanga. So just wanting to understand what that process involved, and I guess how the cultural advice received in relation to the variation is distinct from, say, the submissions that have come forward from the Rūnanga.
Yeah, good question. I'll start by referring back to the section 32 evaluation.
Yes.
And section 4, which outlines the overall approach we've taken to engaging with Ngāti Taua as mana whenua. So we did develop the PDP and Variation 1 in partnership with Ngāti Taua. This involved a large, countless number of hui over the last at least 5 years. I've worked at council on various topics, and also more formally under clause 4A, we have sought formal feedback on draft of the PDP and Variation 1 and received feedback. So we have written feedback from them. And they have finally, through Schedule 1, of course, submitted, and with a large project like this, and changing staff at both our council and the Rūnanga, there's at times shifting positions throughout the 5 years on various matters, but we've at all times strive to work in partnership with Ngāti Taua. So I guess that's what paragraph 13 is alluding to, is that we have that's cultural advice mainly from the Rūnanga on behalf of Ngāti Taua.
Okay, thank you. And is that is there a formal sort of relationship that's been established between the Rūnanga and the council that generally covers this kind of cultural input, or a more specific type of contractual relationship, maybe for the PDP and subsequent variation?
Yeah, there's an MOU between
Right.
council and Ngāti Toa on how we engage together, and that's at kind of a rangatira level, I guess. And Ngāti Toa do have a seat on council committees, and so that's at a leadership level. And then we have a relationship with the Taiao team at Te Runanga, and we do have a kaupapa agreement with them for them to provide us with cultural advice.
I see. Thank you. And just really briefly, if you're able to, from your perspective anyway, at the coalface, how well would you say the MOU in terms of the levels of engagement and the effectiveness of the engagement between council and tangata whenua is actually going? I mean, would you say that in terms of this process, it's helped to generate positive and effective and constructive dialogue and positive outcomes, or how would you describe that?
Yeah, I think so. Regardless of the MOU, we have a duty as planners under Section 8 of the RMA to work in partnership under Te Tiriti, and I think the relationship is very strong. It's helped by, at least in Porirua, by having one iwi group to deal with, so we're not balancing up different views. But I think it's a very healthy relationship, and all healthy relationships have disagreements on the ways we get
Just
places,
like a marriage.
We're both moving in the same direction, I believe. Yeah.
Ka pai. Thank you. Kia ora.
Thank you. So moving to Section 2, statutory considerations. First question is what weight we should give to MFE guidance generally. I'm aware of some pretty ringing statements from the Environment Court in the relation to the Whiteman's Valley wetland decision, saying it was inappropriate to have any regard to MFE guidance seeking to quote, guide, unquote, interpretation of statutory documents.
There's probably a legal case law answer for this, but my answer as a planner is there are some major resource management issues we have to deal with where there is a lack of national direction, and we're in the absence of any national direction, we might give national guidance a bit more weight, because it's really helpful to take natural hazards to have there's a range of guides that are quite useful, technical guides that we rely on. But yeah, it doesn't have any particular weight in a Schedule 1 process, but it's something that we use to inform us as we develop the plan.
And where, like this, you're interpreting the MPSUD, interpreting and applying the MPSUD, where MFE are telling you how the national guidance or the national direction we have should be interpreted. What weight should we give to that?
It's got no legal weight, so you'd always go back to the primary legislation and the secondary legislation, being the MPS. So no weight.
I think this is really a legal question. Just dip my oar in. And as you have identified, the Environment Court has been fairly dismissive in terms of MFE guidance, and I think that Mr McDonnell is correct in saying that it may be of assistance to try and achieve some national consistency in certain circumstances on particular matters, but that's just something that goes into the mix in terms of informing the planning assessment and the decisions that the council makes. But I certainly do not think that MFE guidance is determinative in any real sense. It certainly provides some illumination of perhaps what is intended, but as Mr McDonnell has said, really you need to go back to the MPSUD, if that is the context that we're talking about, and interpret those provisions on their face.
The problem with having regard to something written after the event about interpretation is that hindsight's a marvellous thing. People rationalise all manner of things about what they wished they'd said in a document like the MPSU UD, but didn't.
Indeed.
The other comment, sir, is that the NPS is a national level document, and the exercise that the council team has been doing here needs to apply that national policy document alongside or with policy that applies at a more sub-regional or local level. And so the interpretation, while well-meaning, is not going to provide the substantive answer that, or indeed interpretive advice that you might need across various regions around the country.
Another I'm bouncing off here your comment, Mr McDonnell, at 44, probably we should ask the lawyers this too, the enlarged scope to make recommendations not the subject of submissions. What bounds are there? If anyone rocks in with something from left field that seems like a good idea at the time and no one's submission,
I'll let council handle this because they do address it in their legal submissions, so they might want to expand on that.
And does the good idea component apply to the panel as well?
I think it's so long as we voice it on the face on the floor of the hearing, it's got to be discussed. I think, is that the word?
I think it needs to be. Is it raised?
Raised.
Raised.
Doesn't
within
say
the
who
context.
raises it, so the panel could
Suppose the
raise
panel
something.
can raise something, and
Becomes self-fulfilling at that point. The panel's had a good idea, raises it, and then says, "Well, somebody had a good idea."
So, as we have addressed in our legal submissions, we consider that, yes, this is a power that is given to the panel. However, in our submission, it should be used fairly sparingly and to sort of provide for those incidental fix-ups or where something arises within the context of submissions or consideration of the provisions, that you can see that perhaps to achieve a more integrated approach or to make sure that provisions are going to work appropriately, that there may be other changes that need to be made that just happen to fall outside of the scope of the submissions that are before you. We also consider that in making those recommendations that are outside the scope of submissions, you're still bound by the scope of what can be considered in the IPI. So you're bound by Section 80E, rather than, for example, making recommendations about rural areas or similar.
That's just put in my mind a request I was going to make to the council team. There are, at various points of your combined reports, a statement along the lines, I think you might have cut and pasted it each time. The hearing panel may wish to consider making this an out-of-scope recommendation. I tended to put large NB in the margin of that. Can I ask, as part of your follow-up to you give us, in effect, a table that says Section 42A report, paragraph number, subject matter, where you have suggested an out-of-scope or that either you've suggested it or you've suggested we think about an out of scope, because of course we have a specific obligation to highlight where we accept such recommendations. We have a specific obligations to highlight, and I don't want to lose track of be combing backwards and forwards through the 42A report saying, did you consider this was or was not within a submission point?
Yeah, we can do that. I don't believe I use that particular term, but my colleagues are putting it down. So. Yeah.
That was the sense that I took out of it. Anyway.
Further question?
Yes, Commissioner.
Equally, how does Section 32AA apply to such good ideas?
I would say that it would apply to those good ideas. There does need to be some form of justification for including them.
And then, not only that, since we've already had the pre-circulation of evidence, someone comes up with a good idea and we've already got the evidence, none of it necessarily supporting this good idea, how do we make a decision on what's a good idea when we don't necessarily have any evidence before us?
I think the answer here might be that Clause 100 sets out some requirements for how the independent hearing panel is to provide recommendations. And so in its report, the panel is required to identify recommendations that are out of scope, which are these good ideas that might be raised or identified, but to set out panel's recommendations on submissions and otherwise state the panel's reasons for rejecting or accepting, and then include a further evaluation undertaken in accordance with Section 32AA. So that's the reference there to the evaluation that's needed for these good idea out of scope matters that might be raised through hearings.
But picking up the Commissioner's point, that would suggest support Ms. Viskovic's submission that it's a gap-filling exercise rather than a left-field exercise, because by definition you're not going to have evidence on left-field ideas that emerge during the course of the hearing, and therefore you won't have anything to support them.
Well, that's quite right. And in our submissions, we make the observation that these good ideas do need to be identified and associated with matters raised through the hearing. If it's a brand new issue or a brand new matter that appears and there's no evidential foundation for it, then you do raise or capture these natural justice types concerns, where submitters will be surprised or ambushed by something brand new that couldn't have been anticipated. And the link was made by Ms. Viskovic back to Section 80E, which again is really the statutory purpose for the IPI. So the panel should be aware of Clause 99 and its limit. It's got to come back to the statutory purpose. Otherwise, you're going off-piste in a matter that's not anticipated by the legislation.
I'm up to page 13. Any advance on page 13? Looking first at alignment, and suggested that top of page, development and operation of electricity generation facilities is outside the scope of a district plan. And of course, this plan has REG provisions enabling such provisions. So why is their development and operation somebody want to put a wind farm up on the ridgeline at Pekara Array? That's going to be managed. The development and operation of that facility, if it occurs, would be managed under the district plan. So I'm puzzled. Can you explain that to me?
Yeah. So the bullet point above, I guess, outlines what role a district plan does have in terms of enabling renewable electricity generation. So the PDP has the chapter you mentioned that enables or otherwise manages renewable electricity generation, and then also the PDP addresses transmission infrastructure. but the actual building, the business case for where you build them and how they're operated sit outside the district plan. So perhaps the link wasn't made strong enough to the column on the left-hand column, which reading through the Ministry for the Environment guidance, which I just relied on as a set of matters to work through as I
Dangerous.
had regard to these two documents. That they talked a lot about matters that are outside the district plan, so that's what that's a reference to.
And similarly, further down, supporting rural digital connectivity, you've got a whole lot of provisions in the infrastructure chapter related to enabling telecommunication facilities. So,
Sorry, which?
so this is under the agriculture sector.
Oh,
So I was just puzzled, saying rural digital connectivity is outside the scope of district plan when you're saying enabling it.
I get you. So as far as enabling that infrastructure or managing the rollout of the infrastructure, the district plan is involved, I guess, at that level, but not in terms of some of the other matters that were raised in this guidance I worked through around digital connectivity.
Anyone else on section 2?
73, yes.
73?
Mr McDonnell, I wonder if I could just put the highly productive land to bed, as it were. And if you could clarify that the map that you've got in Appendix G on the land use capability for Porirua, is that essentially all you have to go on?
Correct. That's all the evidence information I'm aware of as to areas that may form may be areas of highly productive land. There are set out in that in the NPS. There are a bunch of other criteria that you need to work through as well. So that information was or that map was provided based on a national data set by the regional council, and with the advice to us that we should not apply it at a property specific level, but it gives us a useful indication of where these pockets might be, and they're relatively limited in Porirua. We're not a highly productive agricultural area, and I don't believe this NPS has been raised by any submitters in terms of their submissions or expert evidence. So and as I my recommendation down in section paragraph 76. In 77, it's the NPS says that it does not apply to a proposed district plan, so it shouldn't have any bearing on the panel's decisions.
Right. And I see it was gazetted, in fact, after this had been notified. So,
correct. Yeah.
Right. So that. Right, I probably should close that down, except I suppose I was interested in the large and geographically cohesive area that doesn't seem worthwhile asking whether any further guidance has come through on what that might mean. But
not that I'm aware of, but yeah, that is a term that's not defined or explained in the NPS, so councils have to grapple with what that means when they apply the NPS.
right.
You're not aware of the regional council are advancing the mapping of those areas and to what timeframe?
I'm not sure if they've publicly set out a timeframe outside the timeframes that are set out in the NPS. They have a large policy development program ahead of them with a change one to the regional policy statement. So I'm not aware of anything imminent.
On the same score, there is the concept of a national policy statement for Indigenous biodiversity that's been like the proverbial mirage that loomed in the distance for more than 10 years. there was a rumour that it was going to emerge in February, but February has been and gone. That I'm not going to ask you what your intelligence about when it's going to be in, because I think everyone's just throwing darts at a dartboard at this point. My question is rather, and it's also a question for the legal team to answer, at what point do we say the next time the goalposts shift, like an NPS IB, it's too late for this process, that my approach consistently when these governing documents has been popping out has been to send out an all points bulletin and ask submitters to advise if they think this has changed their submission for good or ill, to come back and tell us about it. This is, of course, our last hearing. At what point, as say, if it emerges, do we say, well, that's nice, that's for a future process? Or do we have to, up until the day we sign off our decision reports, keep updating every time the goalposts change at a national or regional level?
Can I add to that? There was the way the highly productive land NPS was sort of framed more differently to all the earlier ones, at least in my reading, where it required almost immediate effect and consideration and application. Will that make a difference in terms of the question the chair just asked?
So that's both a planning and a legal question, and I'd welcome your input.
Will be an NPS produced on it.
Yes.
It's quite a difficult question to answer, and particularly...
Yes, I know that. That's why I'm asking it.
and particularly within the context currently where there is so much additional national policy direction being made.
Yeah, because I am aware that as part of MFE gearing up for the National Planning Framework, it's working on a number of the existing NPSs, and they may pop out at any moment as well.
The panel does have a time frame applied to its decision, its recommendation on the IPI. So
believe me, the panel are very well aware of that.
Yeah, and so I think that influences its ability to really take into account things that crop up at a very late time and where there is no real time available for parties to respond in any kind of meaningful way. The other thing I would generally note is that the policy direction often has a time frame by which point councils are required to implement it. So it's not anticipated that it would be done so immediately. Having said that, to the extent that it can, there are clearly some advantages to the panel giving effect to new documents where possible and within the scope of the submissions that it has before it, because of course submitters won't have necessarily raised the issues that are put in contention by new planning, new NPS, and so there will be limits on its ability to give effect to those documents fully in any event.
Yes, because unless submitters have a well-polished crystal ball, they won't have anticipated what a new NPS is going to say and have asked for relief in line with it.
Yeah, exactly.
And is the Commissioner Sinclair's question, do we have to think about the way in which you've implied that we need to think about the way in which an MPS is framed, the extent to which it allows freedom of action.
Yes.
If it's directing immediate action, then maybe that's different. If it says action as soon as practicable, we could decide that it's not practicable.
Yes, I would agree with that. It will be context specific and dependent on what the MPS itself says as to timeframes and how the council and therefore the panel's decision making is influenced.
Any more on section 2? Section 3 is nothing if not short. Section 4, discussion of submissions. Mr. McDonnell, my reading of your section 4 is that there are no decisions we need to make about submissions.
In terms of decisions versus recommendations.
Or no, late submissions and the like. Everything's.
Oh, sorry, I got you. Hang on, I'm just. Which section is that? 4.3.
4.3 looks like Ms. Etheridge has already waived late.
Yeah,
late.
correct. Yeah, paragraph 110. Yeah, the timeframe extensions were granted by under delegated authority. Yeah. It's just noting, I guess, for the panel.
And then just related to that, 4.5, the withdrawal of the submissions. Obviously, since this was written some time ago, have the people who said that they're I don't know, not pursuing a submission or whatever now, were they specific in that they want to either withdraw their submission or they want it to stand and they're just not pursuing that point, such as the, I think it was...
Kaingora is an obvious one.
Or, yeah, or not them, but so, where those flooding matters have been addressed, for instance.
No.
Were they withdrawing or just...
So I'm not aware of
No.
any submission points that have been formally withdrawn, but there are a number. I mentioned some at the start of the day where submitters have seemed to have, seem to be not actively pursuing it in terms of providing evidence or otherwise.
Thank you.
Just further to that, there are a number of instances, particularly in the Part B report, Mr. Ackland, where there's an entry that says, I would also note that Kaingora will not be pursuing, in this case it's the town centre zone at Waitangurua. Other times it's the PDP submissions and they're relying on the variation ones submissions. Have Kaingora actually withdrawn those submissions or are they just not actively pursuing?
They haven't withdrawn any submission point. I did ask this of them a while back.
Yes.
That did they want to actually withdraw them? So they're still on the table.
Okay, we'll obviously follow that up with Mr. Whittington.
We might ask Mr. Whittington to give us a list of the submissions they're not actively pursuing, since he's got a lot to choose from. Section 6, Section 7.
7.8 for me.
So, wait for it. We'll see how far. I'm a bit in front of that. 7.52. Mr. McDonnell, paragraph 217. You say these are more permissive than for non-Papakāinga developments. Is non-Papakāinga developments basically every other form of residential and commercial development?
I'll just pass that question on to my colleague, Mr. Ackland, because he authored that section of the report.
Yeah, by the way, as the way we're going through it, I haven't taken on board who's written each section, so just take it as a given that we can ask you a question, but the author, if it's someone other than yourself, should just climb in.
Yes, Chair, that is essentially it, that it's for just about, it's a way of trying to explain the regime for everything else, but other than that.
All right, and the paragraph 220 is saying, consider the issue is whether the controls should be simplified as commercial activities as notified wording, or more nuanced and based on specific activities as per the wider zone provisions. What do you mean by as per the wider zone provisions in that context?
So in my section 42A, I sort of set out that in the wider zone provisions, commercial activities is actually broken down into its component parts. So office activities, hotel activities. And so the choice is, do you keep it lumped together, as is the current control for Papakaina, or do you break it down into the component parts as per the wider zone chapter provisions?
Gotcha. (7.8) Commissioner McMahon.
Thank you, sir. I don't really have a specific question on this provision, but what it reminds me is, and this is the topic of the general approach to intensification, is that in order to understand some of the relief sought by the various submitters, we really need to have a very good understanding of the mechanics of how the intensification provisions have been derived and how they work. So it's just a reminder at the appropriate time, and was going to be tomorrow in terms of Report B, but it may be earlier, for us sort of a, what I should call a layman's guide or a roadmap to how those mechanics work. And the things I've noted down in particular, in case it's helpful to guide you in that, is firstly how the delineation between the MRZ and the HRZ was determined in divvying up the general residential zone into those two subcomponents. And then, in terms of the HRZ, how the walkable catchments were determined from that in terms of the proximity to RTS and the metropolitan zone. And in relation to the MDRS, two things here, how the intensification areas of the RIP were formulated. That's the increased intensification, if you like. And on the other side of the ledger, in terms of the MDRS, how the height and densities have been modified to deal with, firstly, direct qualifying matters, and secondly, overlays as qualifying matters. And I guess I'm distinguishing in that sense between plan-making qualifying matters and resource consenting qualifying matters. So now I know the answer is it's all in here, which is the section 32 evaluation, part A. But and I'm sure the rest of the panel would appreciate that sort of factual presentation so that we have a good basis to consider submissions against them. And you would have seen some of my earlier questions about 400, 800, 1,000, local factors, walkable catchments, difference between catchments and distances. So that sort of factual presentation and perhaps that sort of GIS presentation that we referred to earlier, Mr. Ackland, about how the 800 metres was then nuanced through the 1,000 metres and the 400 with parks and schools.
So I went at the break to see if I could track down my GIS colleagues
Yes.
for that neither of them were about, so I'm going to have to see if I can get hold of them at lunchtime.
Yeah.
So it might be that I need to suggest that we do this tomorrow.
That's fine.
So I can get them on board, because I think the point being, how does the mapping work?
Yes.
How do we get to there? It's one of those things, it's always easier to see when you see the things sit
Yeah.
on top of each
Yeah.
other, which is the exercise we went through, but obviously you've not had the benefit of seeing that. So I will need to line them up, as well as obviously make sure that this is working.
Mr. Racklin, like, we've got some found time at the start of tomorrow. I think that we're reliant on when they're available. The ideal would be if we started with that at 9 o'clock in the morning, get that kind of description, and then your colleagues would know exactly when they need to show up, and once they're finished, they can go away and resume their day job.
Okay, so I'll go at lunchtime and get that in motion.
Yes, and you're clear on those sort of roadmap questions that I've outlined?
no.
Yes, good.
I'm up to 7.15 on page 88, Commissioners. Any advance on 7.15?
Definitions.
Yes.
Is it 15? 711,
Page?
page 72. Page 72. Just this nature-based solution, this definition in the proposed change 1 for the regional council, does that happen to be in that national planning standards or anything helpful like that?
No, hang on. I'll just check. I provided some an appendix with some wording. I'll just double check if it's in there. The term is defined in change 1 to the RPS. Just trying to refresh my memory if I included it in this report or not.
I think
It's a very broad
Ms.
definition.
Guest, certainly cites it, I think.
It's a very broad definition from memory, and covers a range of things, including water sensitive design, but also reforestation and retirement of land. I've lost the page you're on at the moment. Actually, was it 72? Did you say
72,
Commissioner?
yes. 72 and goes over to 73.
Oh, yeah. Oh, that is the definition.
Yeah, there is some in paragraph 365. There's some commentary from our submission on the RPS, and there is a definition in the RPS, but in my view, it lacks specificity, and it also relies on a number of other terms that haven't been defined, such as a climate resilient urban area, and some of these terms I note have come forward in the provisions put forward by Ms. Guest that are not defined themselves. So.
So really the issue is about the breadth of the definition. So actions to reduce greenhouse gas emissions. Well,
Those-
that gives you a wide field of operation.
But that's
Yeah.
just the examples. They're all,
Yeah.
yeah, rather than whatever else it might.
Okay, I say, any more before definitions? What's that?
Whereabouts, Nick? We've got something on 712.
712, you have the floor, Commissioner.
Kia ora. Just going back slightly to 712, paragraph 409, and you're addressing here the hazard issues raised by Toka Tuake. Now there you're talking about their submission points being largely out of scope because hazards aren't considered to be part of variation 1, not linked directly to intensification of land use, but apply more broadly across the whole district. And I understand your point. But I'm just wondering about, where, for instance, they've pointed out that where you've got high-risk areas coinciding with areas proposed to be rezoned for high-density residential development, would there not be a greater impetus in those instances to look at including provisions that deal with those hazards in the context of Variation 1?
Well, picking up the point, is Ms. Viscovich's agreement that if Variation 1 increases the risk by enabling a greater density on hazard-prone areas, doesn't that bring the way in which those hazards are managed into the frame?
Yeah, they do, and I acknowledge that you could make a case that that these the relief sought is within scope. This particular submitter has not made that link very clear in their submission, but I mean, Council included additional flood maps as a related provision as part of the Variation 1, so there clearly is scope to consider hazards, and as Ms. Viscovich pointed out, there is you do have to consider the risk profile of housing intensification and how you manage hazards. So just getting to the merits of what they're seeking, and there are a few submitters seeking additional hazards be added. They of course need an evidence base to be added. If money and time were no object, it would be fantastic to undertake detailed landslip modelling and include that in a plan, but some of this modelling is quite novel in New Zealand, and we certainly don't have the data to justify including landslips as a hazard. So we had to be somewhat tactical in terms of what hazards we included in the plan. And yeah, flood hazards, of course, is a big one for Porirua and most councils. So that was what we focused on for modelling. I understand that there is you can model. Well, you can certainly model liquefaction, and some plans do have it, but it's very expensive to model liquefaction. And likewise, landslips is very complicated and expensive to model. So we basically, in those instances, fall back on other regulatory tools like the Building Act to manage hazards. So there's the RMA isn't the only bit of legislation that manages hazard risk.
Thank you.
Thank you, Commissioner. Page 88. Retirement unit. You say we'll of course hear from Dr. Mitchell on this question this afternoon, but the thought occurred to me that if the profile of a retirement village has large numbers of what the retirement community calls retirement units, i.e. units that don't have cooking facilities and won't be classed by the plan as residential units, does that mean at a very broad sense, that there's a hole in the plan and there is a need for standards, rules and standards to apply to those units?
Chair, that comes to me in terms of, also I cover the RVA submissions in terms of the actual zones. I think we need to look at the approach the district plan is taking. So it's an activities-based plan, and so it has a high degree of specificity in terms of trying to identify individual land uses and then creating a plan framework or consent pathway for each activity. So this plan has identified retirement villages as the land use activity. It takes the approach of saying that bulk and location standards will apply to them, but not other standards such as outdoor living space, because the district plan and consent authority is probably not the best place to judge on that, given the nature of retirement villages. So purposely it seeks to exclude them, and I think in my report I have recommended some additional provisions just to make that clear.
So the point is that bulk and location apply to retirement village, but not what I would call internal amenity
Not
standards.
the internal amenity standards, and that goes back to then each zone having its own rule for retirement villages, with a policy providing guidance on how that will be considered. So the point, maybe not here, but I've made in my other Section 42A reports, is that the introduction of retirement units, in effect, in my mind, creates another land use activity that's somehow either part of or separate, I don't know, from a retirement village. So I don't know whether it's seeking to trigger a land use activity that has its own consent pathway, separate from a retirement village. And that's one of the things I'm unclear on.
Well,
but my view would be
yeah, you can proceed comfortably on the basis that that was a question I was going to ask Dr. Mitchell.
Okay. So that I thought would be, so it's the retirement village is the land use activity and the controls are set around that. Hence why I've recommended, I don't think we need a definition for a retirement unit because it does not arise in the PDP.
And because you've effectively carved out retirement villages from residential units.
We have, yes.
And I need to go back and and check, but is it clear that a retirement village is not a multi-unit development in terms of the policies governing multi-unit development?
Yes, it is, because again, it goes back to there's a bespoke definition for retirement village and a bespoke pathway for them separate from residential activities, which are triggered by a different consent pathway, which does not apply to retirement villages. So the multi-unit pathway is triggered by a breach of the number of residential units per site. And I think one of the changes I've recommended is making that clear that that does not apply to retirement villages, that trigger. It only applies to residential activities.
Do the policies need to make it clear, or the definitions? Does the definition of multi-unit development say but doesn't include retirement villages?
We've actually, through the variation, taken out the definition of multi-unit housing. And we did that because of the way the MDRS sets things up, so that the number of residential units per site is now a density standard. We previously had as a land use activity standard. So it's a density standard that sits alongside all the other ones for residential activities, such as the, internal amenity ones. So in my view, it is very clear.
Well, we'll have that discussion tomorrow. Any advance on page 94, Commissioners? Well, This is okay. It's about Plimmerton Farm. You're suggesting that you're accepting a submission of Ms. Smith to, in effect, take all the overlays off Plimmerton Farm. My recollection is that Ms. Smith has a number of submissions. There was one that says don't change it to bring Plimmerton Farm into the PDP. There was one, my recollection is that it was specific to one of the overlays. It wasn't saying take all of the overlays off, it was saying, I think it was specific to one of them. Can you assist me? And if my recollection is correct, is there an issue about scope to remove the other overlays?
Sorry, didn't have my microphone on. Mr. Brian Warburton has put in a representation on behalf of Ms. Smith, and in this the pages aren't numbered, but in a table it is pointed out that there's a submission point relating to Plimmerton Farm that was not addressed in the 42A reports.
Yes, I was going to ask you about that too.
Yeah, which I believe relates to significant natural areas. So I intend to cover that in the right of reply in an updated Appendix B. But the answer is I agree with that submission point that the SNA overlay, like all other overlays, should not apply to the Plimmerton Farm site. Could you please repeat the second part of your question around scope?
As I say, my recollection is that Ms. Smith's submission was specific to removing one of the named overlays from Plimmerton Farm.
Not all of them.
But not all of them. Well, but by definition, not all of them, because it was specific. If it had just said remove all overlays, then clearly you would be right. But I'm not sure it did.
I think paragraph 489, submission point 168.36 covers all any provision of the PDP that would result in or attempt to result in the PDP being applicable to subdivision use and development of that site. So I consider that gives you the scope.
I read that as saying don't change it to have that effect.
I think looking at Mr. Warburton's statement for Ms. Smith, he makes 2 points. One is that the provisions of the PDP do not apply to Plimmerton Farm. And the second is, I suppose, reinforcing that with removing the SNA areas that lie over the Plimmerton Farm from the PDP. So they're the same point, I think.
Well, I think the issue I have is about the specificity of the submission, and I wonder if I should just ask you to check it and advise and.
I can do that. My reading of 168.36, my reading is that it would does give scope to remove all provisions that would apply to that site, but I can reflect on that.
Reflect on that, and we'll see what transpires. The question I had about 507, does variation 1 apply to the coastal margin? Does variation 1 rezone anything seaward of the cadastral line.
Seaward of the cadastral line.
Because the argument that Mr Warburton has pursued on numerous occasions is, and we started this in stream one, that there needs to be a clearer definition of mean high water springs so as to control activities close to mean high water springs. Your answer was that the plan relies on the cadastral boundary, and you'd cover anything seaward of that that's still within the district by a note. But the question for me is, does variation one rezone anything seaward of the cadastral boundary so as to bring this issue in scope? Look.
I guess so. The zoning does affect property parcels that are adjacent to the sea in terms of the cadastral boundaries.
But
and
are they
if-
seaward of the cadastral boundaries though?
Yeah. So if you take my recommendation to include some text that covers situations where it's outside that cadastral boundary, or I believe in my right of reply for hearing stream, I think it was one, a deeming, you could include a deeming provision to give it more weight. Then yeah, by extension, yes, there would be land being effectively rezoned beyond the cadastral boundary.
But the point being, it's deemed to be open space. You haven't applied the MDRS to open space zone.
Apologies, I'd have to refresh my memory on the text I've recommended, but I believe it was the zone adjacent to it would be the zone.
Is it next to Hongoeka? That was an exception.
Yeah, there were some exceptions.
Hongoeka was one of them. I remember that.
Yeah, apologies, I'd have to refresh my memory on the hearing stream on reply.
Like the line of thought that I'd appreciate your comment on is whether, first of all, has the variation rezoned anything seaward of the cadastral line so as to bring the exact location of mean high water springs into play? And if it hasn't, is Mr Warburton's submission in scope?
Would the panel, could I provide a written answer to the panel?
Absolutely. I'm not saying right this second, but it's just a chain of thought that I had in my mind. My next one's 102. This is talking about anything in advance of 102. Walkable catchments, the methodology. So that's 529. Reading Appendix H, it seemed to say that you took account of topography outside 800 metres distance, but not inside it. Is that right? Was this a one-way operation? It was a...
It's correct in that the general approach was the 800 did take into account topography outwards. So, for example, Canberra Landing, because of the fairly gentle topography and its fact that it's a master planned development, actually parts of that site are outside of the 800 metres, but to be enabling, and because as I say, it's a relatively flat site, being master planned, we extended it. In terms of within, topography wasn't used per se, but we did use it in terms of looking at making some subjective calls about the pedestrian accessibility. What was it like? So it wasn't necessarily the case that anything over 15 degrees was deemed to be not walkable. It was a number of factors taken into account of topography combined with what was the walkway like? Was it lit? Could it be lit in the future? So in some parts there may have been some slight adjustments, but it was not used wholesale to say, because this land's over 15 degrees in steepness, it shouldn't be included.
I suppose the obvious follow-up is, why not? Like,
The view taken is that in terms of the 800 works in terms of, it's almost like a balance between, because of the such broad variation in topography, trying to get a balance between enabling within the flat land, counterbalanced by enabling in steeper land. There's nothing to say the steeper land can't be developed. It'll be down to feasibility. It's more around whether, as I said, making some judgment calls about whether it was genuinely walkable in terms of the level of access provided. The fact that it was a steep slope was not necessarily stopping the pedestrian shed, if you want to call that, going out to the 800 metres.
yes, you go for it.
Mr. Racklin, I think this section 7.18 is very informative and crucial to understanding of the methodology used, and it goes just to my earlier question about the roadmap. When you do give us that mechanical explanation, I think reference to Table 2 and Appendix 8, H, will be useful. And it might be useful to just take us through a particular high-density residential zone and how it was developed using the two-stage approach that you outline in Appendix H. And
I'll nominate Plimerton.
Yep, fine. Yep.
Yeah, certainly it was my intention to look at, again, subject to talking to our GIS team, to look at one location for the high density and one location for the intensification precinct, to try and illustrate the two.
Yes.
But I still want to have this conversation with our GIS team.
Yes,
but I'll take, so Plimerton would be the one I had in mind for the intensification precinct was Whitby, simply because it does sit by itself, so it's easier when you look at overlays to sort of view it.
Yes. I mean, don't forget we also need to understand, I guess one way of looking at the divvy up process was once you identified the high density residential zone, I guess the rest qualifies as medium density, does it? But you still go through that two-stage process that you've identified.
Yeah, so if it's not intensification precinct and it's not high density, then it becomes the medium density residential zone, and the MDRS applies with some more enabling provisions within that.
Yes.
But fundamentally, that's what
Okay.
applies in that zone.
No, that's fine. And you'll have particular reference to the new qualifying matters that were introduced in Variation 1, such as building height and shading, historic heritage, and sites and areas of significance to Maori.
I would need to refer to my colleague, Mr. Acklin, on that one. I can take you through to
Yeah.
the mapping if you like, but in terms of the actual
Role.
well, actually, the mapping was in part informed by heritage experts on that, so there will be an interplay with them. Likewise, actually, I should say that the mapping of the intensification and the high density zone, there's an interplay with maybe
Sure.
Mr. McIndoe as well.
Yes. Well,
on that.
happy for all three of you
But
to,
I think
to
between us, we'll be able to address it.
yes, because really there are three issues to these qualifying matters. One's the mapping, the second's the overlays, and the third is the district-wide rules, I guess, which also introduce a qualifying matter at a consenting stage. So I'm thinking of subdivision in relation to infrastructure or hazard. Yeah.
The only comment I would make, and maybe it's one for tomorrow, is we have drawn a distinction between an overlay and a qualifying matter in terms of, for us, a qualifying matter is about changing the density. So, for example, building heights. Something like a hazards overlay is looking at the risk of the land use activity.
At that level occurring.
And likewise, so like with the district-wide, take for example, Three Waters, that's, I suppose, a form of district-wide overlay, if you like. But that's not necessarily looking at intensification per se. It's not saying that the building heights need to be adjusted.
No.
So that's where we've drawn that distinction.
No, but the consent process might determine that when you apply the overlay to the MDRS rules and a consent's required.
Certainly, those district-wide matters will have an impact on development capacity, and we've had that modelled in the 2022 property economics
Yes.
model, and we asked them to break it down by overlays so you can build up that picture of what's actually going on, how do qualifying matters impact and how do the district-wide matters impact, and it's more often around the cost rather than necessarily the density being unacceptable, or the building heights or height in relation to boundary is more around other matters, but generally it's the costs that trigger the difference, unlike qualifying matters which are solely to do with the built form and how big and how wide it can be.
Okay, look forward to that tomorrow.
I'm up to page 131, discussing the GWRC submission. 2 points. First might be just an issue of language. In the middle of paragraph 691, the sentence given the national direction to remove car parking, I consider that it would be inappropriate to apply it as a qualifying matter despite the lack of supporting analysis. Is despite what you mean? Seems to be going the wrong way.
Yeah, I looking at that, it'll probably be it's a case of it's inappropriate because to put that in would have the effect of introducing car parking potentially, and also there is a lack of supporting evidence. So I suspect what's missing there is an and.
Yep, okay. And more substantively, 694, no site-specific assessment. Does there need to be one? Is this in the general category, or is this A to G?
The one to do with the car park, in my view, would be the catch-all.
Go.
Kia ora, Mr. Reckland. Just on paragraph 695, this deals with Greater Wellington Regional Council's request for a new qualifying matter to restrict building heights adjacent to SNAs and sites and areas of significance to Māori. I just noticed in your paragraph here, in dealing with the issue, you only address the SNAs, not the sites and areas of significance to Māori. And then in paragraph 698, where you set out your recommendation of not being satisfied that Greater Wellington Regional Council have provided enough information to satisfy the statutory requirements there. Again, there's no mention, I don't think, of your response to their submission point in relation to sites and areas of significance to Māori. So I was just wanting to confirm really with you what your position is in relation to those. Is it the same approach you've taken?
Richard, that is actually, it's one of these ones, it's split between two authors.
Oh,
so
okay.
Mr. Ackland deals with the sites adjacent to SASMs. I have
Sorry.
stuck, but you're right, I probably need to amend that to make it clear that when I speak to their submission point OS 74.60, it is limited, in my recommendation, just to the SNA side of it.
Okay, thank you. So we'll get clarification on the SASMs at the appropriate time. Thank you.
And I think the answer is that Ms. Racklin is recommending a constraint, and Koyangora are saying that are opposing that recommendation.
Okay, thank you.
I think we might have a break for lunch. I think we're going along quite sweetly in terms of the timetable, so we'll take the full hour, be back at 1:30. Rest and recuperate in the meantime. My next question's on page 139. Any advance on page 139, Commissioners? Not sure which one of you this is addressed to, but the suggestion at paragraph 739, this might be an out of scope recommendation. The other option is that, given that it's a statement in an introduction that's duplicating a statement in a different introduction, it might be deleted as a clause 16 matter. What's your view about that?
So which paragraphs?
739.
739.
This is about the request to delete a statement about controls.
Just Ben, I need to pull that up because it's not in my...
Thanks, Chair. So that's in relation to to the historic heritage topic. So I'm happy to answer that. So whether it could be a minor error, I certainly think it would be, if there is an ability to consider it, whether it's through scope or minor error, it is some aspect of duplication because there's similar topic wording in other chapters, but in terms of the precise whether it fits as a minor error or scope, I might need to give that some further consideration.
Yes, because if you don't think it's a minor error, I think I need you to tell me why.
Yeah. It's a statement of fact. It's saying that something is notated on the planning maps, and that is correct. That there are height controls on the planning maps, so it's not an error as such.
Well, it's unnecessary, but so leave that with you. Next, I get to 164. Any advance on 164? About whether Mana is a town centre zone or should be classified as such. I note from Mr. Whittington's submissions that Kaingora is not pursuing this issue, so we'll take that as a given. But just in terms of the national planning standards, do you think Mana qualifies in terms of the definition that's in the national planning standards?
To be able to answer that, I think you need to know on an evidential basis of the function and capacity it actually serves in. And I don't have that in terms of, I don't know whether it serves neighbouring suburbs, etc. So it's to me, to determine whether something will be which zone under natural planning standards, there is an element of evidential basis needed, and I would suggest we don't have that. We have a suspicion that it might be, but part of that might be because of its historical development along a state highway, as opposed to where things are now and where they're heading. In terms of our policy approach, the PDP seeks to focus on local centre zones spread throughout the city to deliver the outcomes it's seeking in terms of support and intensification, and the other outcomes in terms of set out in the strategic objectives. So in my opinion, I'm not sure that we've got sufficient evidence to make that call, But from policy approach, I would still say that the local centre zone is the most appropriate.
Well, given that Kaingora are not pursuing the matter, you might suspect that perhaps they agree that there is insufficient evidence to justify it. Now, next is, for me, is 168, where I'm into the strategic objectives. About UFDO 6 at your discussion of the Section 32 report at 912. I was thinking to myself, what is a healthy built environment? Like, there's a healthy environment for people, but what's a healthy built environment?
So a healthy built environment, for me, is a number of factors, and to some extent, this comes from the Mackinac Urban Report, which looked at this matter, where they did a literature review of health and well-being being informed by the built environment. So it can occur at a neighbourhood level, but it can also occur down at the single house level. So it'll be things like a healthy built environment is a walkable environment. At a neighbourhood scale, it means having access to parks, amenities, etc. But it also then goes down to more site-specific in terms of having access to sunlight and daylight, thermal comfort, which will be derived from the Building Act. So there's a number of factors that will contribute to a healthy built environment, but they are spatially different. And the PDP approach is to use the district plan in a way that goes towards achieving a healthy built environment, because the effect buildings can have and the quality of access to outdoor living space and access to sunlight, and those sort of, I suppose you want to call them internal matters as well.
Well, that's all I had, Commissioners. Anyone else have anything on the overarching report they want to raise at this point?
Mr. Chair, I have an expert here, Mr. Osborne, and we kind of skim past the property-based flood map.
Which Mr. Osborne?
Oh, Mr. Alistair Osborne. And
Because since you've got two of them.
There is one submission point in particular. I think it would be worthwhile having him just talk the panel through his expert evidence in relation to a submitter who's appearing in person later this week, Alan Collett.
If you'd like to interpolate Mr. Osborne, now's a good time.
Thanks, Commissioner. So
I think that is the camera going to pick him up in the back row, out there on the cheap seats, or whether ask him to step forward and sit next to Mr. Wakefield?
Yeah, it'd be best if you could come up to the table just for the cameras. Thanks, Mr. Osborne. I can give a brief introduction quickly to the to what he's going to discuss. This submission point is covered in section 7.13. The submission point is paragraph 437. So the submitter, Alan Collett, seeks review of the flood zone overlay at 42 Grey Street, and considers the mapping as flawed and not reflective of the true topography of the area. So I thought it would be worthwhile having Mr. Osborne just talk through his methodology, assist the panel when Mr. Collett appears in person.
7.12.
And it might be worthwhile if you've got Mr. Alistair Osborne's evidence in front of you, a statement of evidence on flood hazard modelling. It's covered in paragraphs 35 to 43, and there's a couple maps in there showing how Mr. Osborne has recommended the mapping be revised in relation to that property.
Well, I wonder whether the smart play is, Mr. Osborne, you make any general comments about your evidence in total, and then we'll focus on specifically on the section related to Mr. Collett's property.
Okay, thank you. Actually, I'm not sure entirely what sort of general comments I should make.
If you don't feel the need to make any, none is a perfectly acceptable answer.
Okay, thanks. Other than, our modelling is done to a regional specification that we've developed for this purpose, and our models are validated using recorded events and through community engagement. But also, I guess, relating to this query in particular, our models are based on data that represent a moment in time. And in the case of Alan Collett's submission, he questions whether the topographic information we've applied in our model is correct. Well, there are two facets to his submission. One is that our model doesn't correctly pick up earthworks that happened during the development of his site. And then also that our model doesn't correctly pick up the level of the top level of the grassy verge and driveways at the bottom of the Grey Street cul-de-sac where he's located in Porirua Bay. And so in my evidence, I've argued that our model does pick up the earthworks that have taken place. Is it all right if I proceed, or are you still? Should I wait until everyone's tracked down the section?
I think probably.
I'm sorry.
Okay, so talking about.
Yeah, the model topography. His other point about whether or not we've adequately represented the topography around the bottom of the cul-de-sac relates to whether or not when the stormwater system overflows, it would be captured and essentially stored within the cul-de-sac rather than spilling over into his property. And while our modelling is based on fairly old topographic information, as a LiDAR survey flown in 2013, we do. I have checked. We ran to review his submission. We ran a couple of additional model simulations, trying to ensure that we better represented the levels around the cul-de-sac, and we found that even with the levels he had provided, the sort of the height of that grassy verge, we're still finding that our model predicted, that water would spill onto his property from the cul-de-sac. So I guess the crux of the issue is that even though there may be some inaccuracy in the topography used, there is still very likely water that will spill onto his property from the cul-de-sac. Moreover, the nature of our modelling is to model clean a clean stormwater network system where there are no blockages due to debris and the like. And unfortunately, in this case, the property in question sits at the bottom of a cul-de-sac that slopes down towards that property. And in the event that there were blockages to the inlets, to the sumps along that road, along Grey Street, water would essentially hit the bottom of the cul-de-sac and carry on through the property to the essentially following a natural drainage path to the gully behind his property at 42 Grey Street. And so the update we've opted to pursue is to remove inundation from Alan Collett's property, but replace it with an overland flow path, because we feel we need to protect essentially that natural flow path that does exist from our modelling and just from looking at the site, so that building can't take place there where it would block water running from the cul-de-sac to the gully. Yeah, I think that's the.
And that's down the, I'm not sure which
Sorry.
direction.
So these are images 10 and figure 10 and 11. I apologise. There's also a image referencing error in my document at paragraph 43, where I talk about figure 12, and then it says error reference source not found. Figure 12 is also wrong. That should say figure 10 and figure 11 in paragraph 43.
So the point you're making is that the natural flow path is down the fence line.
Yes, yeah, and if you were to look previously in the image, in a Google Street View image, which is figure 9, you'll see that actually this is an image looking down south from the cul-de-sac to number 42 Grey Street. You'll see along the left-hand side in the image of the house, there is a designated, well, I don't know if it's designated, sorry. There is a piece of flat land that that the flow path would follow. Yeah. Our model indicates that water spills along that left-hand side of the cul-de-sac, down that piece of flat land.
Question.
Go for it.
Just on that figure 9 street view, is that a double catch pit in front of the curb there?
Yes, it is. But
Does that what effect, if anything, does that have?
Unfortunately, not unfortunately, in the event that we've modelled, which is a very large extreme event, that catch pit actually surcharges.
Right.
Because of flow arriving from further up the road. Yeah. So it's unfortunately a situation where if that catch pit wasn't there, water wouldn't surcharge, but it also wouldn't discharge any water that arrived at a location on the surface. Yeah.
Thank you.
Yeah.
Go for it.
Mr. Osborne, based on your site visit then and the changes you've made, is there any way you would change the modelling that you've used?
Only I know that no. Ideally, when we receive new topographic information, we would update that because the topography in the future we will get better resolution topographic information, but at the moment I wouldn't change the modelling. We did one thing I hadn't covered, was that we, along with while working with Alan, we found we had misrepresented the sump leads, which is the small section of pipe draining from the sump to the stormwater network. So we reran the model with the correct subleads in, but it made no difference, unfortunately.
I suppose I asked because I was looking in your evidence at your response to the earlier submission on the Latter-day Saints piece of land.
Yeah.
And I suppose this, what I wonder if you could say what caused the mapping methodology to fail in that particular.
In that case, the nature of our models is a subcatchment-based model where we draw small hydrological subcatchments which convert rainfall into runoff. And in the case of the Latter-day Saints, we had set it up so that water discharged directly. Actually, I'll backtrack a moment and say our subcatchments discharge generally to the pipe network. If there is a pipe network adjacent or in the area, or they discharge directly to what we call the 2D zone, which is the model surface. In the case of the Latter-day Saints, we were discharging a subcatchment to the model surface where, upon review, given the topography where it was quite steep, I thought actually it would be more likely that in a normal model setup, we would discharge it directly to the network. And so the extent of flooding we saw there was not realistic.
Right.
Yeah. Or realistic in terms of modelling. Yeah.
I mean, I'm just tracing through because your next example was in Parramatta Road with Deborah Ashton, and I think you've updated your information. Was that right in that case? And there'd been better drainage.
Yes, or no. So we hadn't updated our information. The better drainage that had been put in place did not relate to the cause of the flooding that we were modelling. Yeah. So it was, without wanting to seem dismissive, it was not relevant to the flooding.
Right. And in Mr. Collett's case, you said even though you didn't have quite the correct information in terms of the drainage, it wouldn't have made any difference to your calculations.
That's right. Or and it didn't in terms of the sump leads, because that is something where we could make an immediate change to the model. We did change the model to include the correct sump leads, but we don't have suitable topography data to make a change across the whole model.
Right.
Yeah.
I mean, does it make you feel, do you feel comfortable about the degree of accuracy you have across your whole model when individual examples crop up?
Yes. We are always constrained by the best information we have. And so our modelling is based on the best information we have. And we do, won't say rely on, we undertake community engagement with the aim that people will raise issues if they see them. And because we are working at quite a large scale, it is a struggle to ensure that we capture all the small detail that may create differences in reality to what we have modelled. So I guess it's with the based on the information we have, we're confident that our model is providing an accurate representation of flooding.
But Duck Creek's an exception.
Sorry? But, Duck Creek, we know that's with Duck Creek, there was we knew that we didn't have the correct topography, but we knew that topography was going to be collected. So we progressed the modelling as far as we could, and we generated draft maps based on the model, knowing that we would have this hearing process to correct it when the updated topography came in, which we at the time understood would be at the end of last year, so November or December. Unfortunately, there have been delays to the collection of that topography, of that LiDAR survey. So we have said we know that this is wrong, so we should remove it. Yeah, and it's wrong on a broad scale.
Mr. Osborne, just following up on that line of inquiry, for those submitters that haven't availed themselves of us to challenge the whether it's the ponding or the overland path or stream corridor, what's your understanding of their options that are available to them once the plan's operative?
A great point. So there's always my understanding is there is always the avenue of appealing the rules that are applied. So these zones represent rules in the plan around what can be done in terms of building. And so there is always the option to appeal that, and in which case we would either require them to undertake modelling to prove that ours is incorrect, or if there is a case for it, we would undertake the modelling on their part. Yeah.
I'm sure the chair might have a follow-up question there, but
Can I just clarify something
Yes.
Sorry.
with the expert?
Sorry.
So you mean by appeal, you mean the resource consent process
Yes.
provides
Yeah.
an
Sorry.
avenue to...
Yeah. Rather than appeal the
Yes.
plan. Sorry.
yes.
Yeah.
So
No,
the
it's
delineations,
Yeah.
whether it's ponding or overland path, are a trigger for consent.
Yes.
And so at the time that those rules are triggered for a particular property that's subject to one of those notations, then either the applicant would do their own modelling, or the council would on request.
Yeah. Well, yeah. Oh, I guess and I don't know. I don't know if there is a clear boundary or delineation between that decision of the council doing it or asking us to do it on their behalf.
Right. But there might be other situations out there where either the notation's removed entirely, or it's downgraded, or possibly even upgraded.
Yes.
Depending on the more nuanced investigation that's undertaken in the absence of that at the broad level.
Yes.
Yes.
Yeah.
Okay. Okay. My questions that follow are really planning ones, but not relevant to this one.
I've got some more
On this
this
issue?
as well.
Well, you go on this issue because I'm going to something different.
Okay. So on the next one, which was just the bit about Greater Wellington and the northern growth area that you've addressed in your evidence 32 to 34.
Yeah.
Sorry, when you say in 33, correct and suitable modelling will be undertaken to enable the development of the ponding areas for the inclusion of the northern growth areas within the PDP.
Yeah.
So, sorry, my question is, when is this modelling going to be undertaken?
That is perhaps an error. We have actually undertaken that modelling, and the images below it, which unfortunately my computer's locked itself, the images below it, which would be maybe 5 and 6, represent the modelling that the original. Well, modelling wasn't done originally. We mapped. It was a mapping exercise, and then Figure 6, I think it would be, represents the modelling that was done for that northern growth area, which then includes the inundation.
Okay, so it's actually, the modelling has actually
Yes.
occurred.
Yeah.
And so
Is
we could ask Mr. Smeaton then, is that fed in as a planning follow-on, has that followed into the northern growth area?
Yes, I've addressed that in my Section 42A report for the Northern Growth Area.
Yep, thank you.
So that was the first of the questions I was going to ask. And the enigmatic statement of paragraph 34, need to refer to and explain the relevance of the two
Yeah.
figures below. I think you've done that.
Yeah, sorry, that was another error. In that, yes.
I want to take you back to higher level question. Paragraph 12, including 100-year AEP, including climate change.
Yes.
Since I live in Hawke's Bay, which is this is a currently hot issue, to what extent have you considered the effects of climate change?
So we account for climate change using a sea level rise of 1 metre. And we've applied that around the region. That was established back in, I think, 2016 at the outset of the Wellington Stormwater Modelling Panel, and it was done in discussion with Greater Wellington. And then, so that's the sea level rise component. We then account for climate change in the rainfall by applying a 20% increase, which is based on a projection of, again, when our modelling started in 2016, there was HERDS version 3, which is, apologies, the NIWA high intensity rainfall. I've forgotten the rest of the acronym. But it's a design rainfall calculated by NIWA. And the climate change predictions applied there didn't go as far into the future as we desired. So we, Wellington Water, in discussion with Greater Wellington and NIWA, came up with an approach for projecting to the year, I think, 2130, and calculated that the best way to allow for an increase in rainfall to that date was to apply a 20% increase.
So your question was, how does Hawke's Bay relate to that 20% increase?
I'm sorry, I don't know. Apologies. Sorry, I missed that aspect of the question.
Or more generally, when was that work done?
That was done in 2016 and 17.
And to what extent, if any, have the events of the last 6 or 7 years indicated that was conservative, optimistic, or somewhere, but that 20% projection, conservative, optimistic, or something somewhere in between?
I don't know if they have that much bearing. These were the events in Hawke's Bay and Auckland were very extreme events that do sometimes happen, unfortunately.
And once they've happened, they skew the probabilities of it happening again.
Or if they change the frequency analysis that's undertaken, but the climate change predictions are not based on frequency analysis. So yeah,
Better tell us what they are based on then.
they're based on modelling done by the IPCC.
Okay.
Unfortunately, that is not my area of expertise, so I'll very promptly back away from saying anything more.
Anything more from Mr. Osborne? That's it from us.
Thank you
for
very
your
much.
assistance.
Thank you.
So, Mr. Marshall's passed me a note to suggest that we might hear from Mr. Bowman and Mr. Vossler at 3 p.m. by Zoom, now being 2:05. What do you propose we start next with team?
I've been trying to get hold of our GIS team, and I still have had no joy. So I'm just thinking it through in terms of the request to demonstrate the walkable catchment and then how we approach intensification. And I'm just wondering if I can't get hold of them, whether depending on whether you're happy to maybe split that presentation or do you want to see it all together in one go? In which case, because I'm basically on the stand effectively most of tomorrow, whether I won't be able to speak to them, explain what we need to do. So whether my bit on that particular aspect is moved to the Wednesday morning when I can get them to actually be available. It might be that they come back to me this afternoon, but I'm still waiting as we sit now. So whether we turn for the next hour to the Part B residential zones, planning maps and general topics, if there are other topics within that you're comfortable to deal with in advance of hearing that information.
I think given the size of your residential and general folder, we might conceivably find something useful to occupy the next hour on. So we'll do that. We'll start with the residential. If our questions trespass into the area that in your mind you want to deal with as part of this GIS, just tell us and we'll park them.
Okay. What I do have a brief update.
Yep.
So obviously I have done a supplementary, and I did make a change, which Chad, you alluded to earlier about additional high-density residential land at Kenepuru and additional building heights. It's also come to my thinking about it. I think that HR said Objective 1 needs changing to allow for that change. And with your permission, I do have a copy of what I would suggest how the change could take place and the submission point that would allow for that. So I can ask someone to provide a copy of it and I'll get it posted on our website.
Yes, please do, and we'll go from there.
So I'll just wait for Mr. McDonnell to have a chance to look at that. So in my supplementary, I've recommended that we do accept the 36-metre height limit for that part of Kenepuru in Mr. McIndoe's evidence. So I believe that Clause 1 to HR said Objective 1 should be amended as sought by Kainora to specifically reference the 10 stories that would enable. Over and above that, there's no other significant changes from my supplementary in relation to the residential topic.
Right. Thank you.
So the other thing I was just going to suggest is planning maps are included within this report. I was wondering whether we might want to take the commercial zones parts of it and attach it with the commercial zone report, and stick with the residential zonings, walkable catchments as part of this report.
Okay, well, we'll try and keep in mind on that. Are there any other more general introductory comments you want to make?
No, I'm happy to go to questions.
Just before we go to specific questions, just can you help me with some terminology? Can you explain the concept of height variation controls and how they differ or relate to intensification precincts?
So there's two sets of, if you like, of height variation controls. Now we've tried to label them so that they say what they are. So you've got height increase A and height increase B, and they are applied in the commercial zones to increase height limits where they are within walkable catchment of the metropolitan centre zone and or a train station.
Okay, so they are commercial zones only.
Commercial, they're to lift, in those locations, there's site-specific controls to lift heights up above the underlying zone height limit. We then also have height variation controls that actually limit the height, and those are height limit. They're labelled in the PDP maps as height limit controls, and there's a number of them relating to shading, but also for the sites adjacent to historic heritage and sites adjacent to SASMs.
Yep.
So they're targeted site-specific controls to either increase a height or decrease a height.
Yes.
What's
to the
the
zone.
term of art that you used for the increases?
Pardon?
What was the term of art you used for the increases?
It's height increase
Oh, so
A or height increase B.
So the A and B are both increase types, and then the next one you're talking about is
Yes.
neither A or B. It's called a height limit control.
Yep, I'll just bring it up so I've got the exact terms. So the ones that are decreasing are, in fact, sorry, they're labelled per the qualifying matter that they relate to. So, for example, you have height control shading A, where the height limits are lower. You have height control heritage A, where the heights are lower, and they differ because of the.
can you repeat those terms?
Yeah. So I'm looking at, for example, the high density residential zone, and that's HR said S2.
Let's get
that Can't- in
front of us.
So
I was wondering whether we could get the PDP up online. Might be
If you need it.
easiest to step through it.
Here we are.
Yeah.
S7.
S2, did you say?
HRZ
Standard number.
S2 height.
So it'll be HR said S2 deals with height.
Yeah.
So I'm using this as an example for high density residential zone.
Yeah.
Let's see.
So we've got shading A, which is self-explanatory. Then we've got heritage A and heritage C. What's the difference?
So they relate back to that qualifying matter in terms of lower height limits on sites, on identified sites adjacent to historic heritage, where the height limits are lowered in a way to protect the values of the heritage
so
item.
does the A, what does the A stand for or relate to? And is that just relating to, that's the 11 metre height limit, and C is the 8 metre height limit?
So that is aimed at trying to be more nuanced, say in some places that the 11 metres is what needs to be limited, in others it's 8 metres. So it goes back to the methodology for applied in relation to what is needed to protect the values of the historic heritage site.
That would suggest, Mr. Ackland, that there's a difference between the heritage resource that affects heritage A and the heritage resource that affects heritage C.
I would have to defer to Mr. Ackland and to
Yeah.
the heritage experts as to how they arrived at 11 metres versus 8 metres on particular sites. But the approach has been to do nuanced site-specific controls to the minimum necessary to protect the value, but still allow for intensification. So it's a balance.
This is where the mechanical explanation is critical, because we're starting to delve into submissions that are challenging these principles and rules without a full understanding of how they're being derived. I don't know the answer to that.
Oh, well, we'll do
So,
that.
well, can I say, so there's a heritage A is 11 metres and heritage C is 8 metres. What's a heritage B?
That applies in,
Not in that zone.
Not
so-
in that zone.
So therefore it's not.
so they're,
okay,
they're
yep,
zone-based
Right.
provisions.
So that this is where, within these zones, they adjoin them, or actually within that zone, or what about in the interface between the two zones, do the same provisions apply?
Because these are done by us, and it goes back to
Yeah.
Commissioner McMahon's point, on a planning map, which I'll show,
Yep.
it's done on a site-by-site basis.
Yep, sure.
So where it falls, there's a bespoke height limit per site, and that's the intent of this control. It's a very bespoke control per site.
So just out of, how many heritage type height control things are there? A, B, C?
Oh, I can speak to that. So there's there's the heritage A, B, and C height controls. There's also height in relation to boundary controls. Heritage A, B, C, and similarly for height in relation to boundary control SASM, there's a
Right.
one for height and one for height in relation to boundary. And yeah, in terms of, I don't know if you'd like to know the number of sites that are affected, but spatially, but those are the, I guess, the names for those particular heritage type controls.
Okay. And then for shading A, how many shading A, B, C, Ds are there?
There are in total, so we've got A in this zone. And then in the medium density zone, there are,
What was the number in HRZ?
so in terms of shading,
Yeah.
it's only one, that's A. In the medium density zone, you have a shading height control shading B, height control shading C, and height control shading D. And they work on the same principle of being bespoke to identified sites in a way that is the minimum necessary to achieve the outcome. We could do if they can bring it up.
Okay, so I kick that question off, Mr. Racklin. You said that there's two types of height variation controls, ones that lift and one that decrease. And we've just gone through the ones that decrease based on the qualifying matters of shading, SASM, and historic heritage. For those that lift, did I hear that they apply just to the commercial zones?
They do. The ones that lift just apply to commercial zones.
Okay. Okay.
Now, we do have online the PDP maps. I could zoom in on some of these site-specific controls to show.
Just before you do, and just bear with me for a minute. I guess the quid pro quo for those that lift in the commercial zone are the intensification precincts in the medium density or medium residential zone. Is that correct?
Well, those height increase are to deal with NPSUD policy 3C 1 and 3, I think, apply. It's the idea being that you also have to increase building heights for commercial zones as well as just for residential.
Yes.
So it's urban intensification across the urban environment in those particular
I think
locations.
3D says within or adjacent to heights
So,
within local centres or metropolitan centres.
so those height increase ones are within the commercial zones. I think the main ones they affect are within the local centre zone and within the mixed-use zone. And again, they apply to specific sites.
Well, I think it would be helpful if you just gave us, zoom in on an example that you can take us through.
Just to make this easy, I'm going to click off some of these layers so that we get to the height control ones. So where you see the hatching, that indicates that there is some form of height variation control. So if I click on this property here,
Sorry, can I just clarify, Mr. Racklin? You said height variation control. Is that a new bit of terminology, or do you just mean height control?
it's a piece of terminology which actually comes from the Auckland process. The idea being a variation of heights
Right.
being enabled or disenabled.
Right.
A variation from the norm.
So I just got confused because up there it says height control variation 1, but we're talking about height variation control variation 1.
That's the generic term that is given to a site-specific control that seeks to vary a height above or below the. So having clicked on this, this tells that they are subject to a height control of shading B.
So what was that address? So write this down so I can.
That is
17 Carbine Place.
So I'll just go to that. So that's in the medium density residential zone. I just got to get the variation 1 version up. So on that site, and only on that particular site, the height limit, instead of being 18, because it's actually within a medium dense, within a residential intensification precinct, instead of being 18, it's 14 to address the adverse effects of shading down the slope.
That's quite a good example of where your standard MDRS has been increased because it's in a RIP. but then decrease because it's subject to a shading limitation.
To that particular site,
Yes,
yes.
yes,
Coming and going.
yes, yes, okay, and I'm starting to get it.
Thank you for that example. And
Just looking at other permutations on that, Mr. Racklin, if we chose a site that was not in the residential intensification precinct, so it was subject to the 11 metres height, the 3x3 rule, is it possible that there might be properties that are affected by shading B which have a lesser height than 11 metres? Or is the minimum enabled height always going to be 11 metres?
The,
Do you understand what I'm saying?
yeah, I think I do. I'd just say that you've got D as well,
Oh,
which
okay.
is 9 metres.
Sorry.
So
okay.
that will generally be where you don't have an intensification precinct, where the height limit otherwise would be that,
Yes.
but because of the shading control, it's that.
Yeah.
Whereas 18 metres in residential intensification
Gotcha.
precinct decreases to that.
Yep. Yep. And in fact, if you look at E, it could go down to 8 metres where it's affected by shading D.
Yes. Yeah. So
okay.
again, it's a sliding scale based on the actual effects at that particular site.
Sure. And these are actual plan making, plan locked and loaded reductions in height, aren't they?
They are. Yes.
Yes. They're not determined on the resource consent process.
No. So the resource consent process allows the ability to then assess those downhill effects.
Yes.
But the modelling, and Mr. McIntyre undertook the modelling, so he may be able to speak to it. Did a site-by-site analysis to look at what was the effect downslope from the sites and what level of control was needed to achieve a balance between allowing the downhill slope properties to still get a level of access to sun, but still achieve the overall intensification aim of the
Yes.
NPSUD.
Yes. All other things being equal, these are permitted standards. These are standards on permitted activities. So, putting aside district-wide rules and other overlays, hazards and that, these are the maximum heights that could be established on those sites.
They are. And Property Economics, when they did their modelling for loss development capacity, modelled the loss from these sites. So even with all of these controls,
Yes.
the amount of plan enabled is still probably close to 100% more
Yes.
than the 30-year need.
Yes. Just carrying on there, because I'm finding this useful. I think the site was was it Carbine?
Carbine, 17 Carbine Place.
Yeah, and that was the 18 metres. If hypothetically there was a flooding overlay over the top of that, either for stream corridor or overall overland path, whatever, the 18 metres still applies presumably, but the rules relating to the overlay have to be considered at the same time at the resource. Presumably they would necessitate a resource consent.
They would, but it would be based on the land use activity.
Yes.
That was what would trigger that control.
Yes.
So this is to the building. What use takes place within that building doesn't matter because the effects are from the building.
Yes.
The natural hazards overlays are concerned with the sensitivity of the land use.
Yes.
To some extent, that doesn't necessarily equate to building height.
No.
So a two-storey aged care facility is probably more sensitive to hazard risk than a 20-metre high
Sure.
industrial warehouse. It may do
Yes.
in some cases, but the trigger is the sensitivity of the land use. This is solely concerned with the effects of
I
buildings.
understand that. So the outcomes of that resource consent might be the imposition of a minimum floor level.
Which will go to the how many stories you can get.
Yes.
So that's why we sought property economics to model overlays and these. So what was the combined picture of the level of controls that were being imposed?
Yes, at the extreme end, the outcome could be declining the consent because the flood risk is deemed to be so high.
Yes, because it's depends on the activity. I think it's still non-compliant is the highest one.
Stream corridor.
Non-complying for a hazarded sense of activity in a high hazard area.
Yes.
I'd also add that a lot of the high hazard areas we've mapped are stream corridors, and they might just clip the corner of a property where you may be able to get your maximum development out of the rest of the site, but in that small portion of the site, it will be non-compliant.
Yes, so the entire site's not affected, it's just that part of the site affected by the corridor.
Quite nuanced, yeah.
Yes. Okay, the picture's starting to develop, thank you.
Kia ora, Mr. Ratcliffe. Just a really quick follow-up question from me, because this has been really, really helpful in understanding what the height variation control areas actually are, and there is a lot involved, obviously, in determining where those areas are in variation 1. I'm just wondering whether there is some merit in including a definition of height variation control areas in the plan.
My immediate thought would be to either have a definition or maybe in the how the plan works to explain it. So whether it needs a definition or it could sit in there, I'd probably give a little bit more thought to. But I think the general point is, yes, it would. The plan would benefit from somewhere recording what is height increase control, what's a height decrease control. Whether that's a definition or how the plan works, I probably just want a little bit more thinking about it, but I think the point is correct.
Thank you.
Sorry, it just struck me that while we're on this roll, we've talked about the effect of hazard overlays. What would be the situation if 7 Carbine Place had been affected by a scheduled heritage listing?
So, as in, it's within the heritage overlay
Well, I'm not
Or
too.
adjacent there too.
or adjacent.
Well, I'm not sure what I'm asking here, and I'll tell you why. I mean, presumably, the plan contains a schedule of heritage items and buildings, but presumably has a heritage overlay as well, or are they one and the same?
So the plan has a schedule of heritage items and settings.
Yes.
A schedule, and two schedules actually, and a schedule of sites and areas of significance to Māori.
Yes.
And they are spatially defined.
Yes, and so they'll be they won't be continuous sites necessarily. They'll be dispersed throughout the district.
Yes, they're primarily dispersed.
Yes.
So there is some overlap with a couple of portions of sites of significance to Māori and heritage, but they're primarily individual sites.
How does that contrast with the heritage overlay? Is the heritage overlay something different, or are we talking about the same thing?
So those schedules, I'd call them the heritage overlays.
Okay.
And then the height controls for sites adjacent to heritage items and settings and sites and areas of significance to Māori are different. A different matter altogether, but
Understood.
related.
So to answer my question then, if for argument's sake, that number 7 Carbine was affected by a heritage listing, what would that mean? Is it a different outcome to the flood hazard?
I think what I'll do is I'll go back to there because I can show how the plan works in that respect.
Do you mind?
No, go. We've made some time.
So what each chapter does that's got these overlays, I'm using that in a more generic term, where that overlay has the effect of amending a density standard, we have identified them at the top of... So these are, if you like, from the PDP controls that have the effect of limiting density in one way or the other. So take your example of heritage. So this is saying that any new building needs consent.
Just while I'm
That's a density standard.
just while I'm thinking about that, Mr. Racklin, that explanation is the explanation for what's in immediate legal effect and what's not, and it will drop out at the end of the process, which comes back to Commissioner Pomare's question, whether there ought to be a more permanent statement, presumably in the how the plan works section.
Or thinking out loud, and I haven't thought this one through, whether we retain that, as you're correct saying, that the purpose of that was to show what has immediate legal effect. But I would also say, for me, I find it useful to actually have it listed at the start of the chapter.
It's basically an index of all of the things that the Commissioner's interested in.
Yeah, because it becomes that, almost like a user guide, you work your way through to make sure you're not.
How does that provision work? Do they automatically drop away, or is it a council discretion to remove them without further formality? I can't recall which. I know
I have to come back to you on that. I haven't thought that one through.
I know there's a process to get for them to drop out. Everyone's looking very puzzled. Like as I say, if somebody could look it up and give us the answer, that'd be helpful.
So hopefully, Commissioner McMahon, does that help? So this is the intersect between this rule and the height. So that's not limiting the height per se, it's limiting the number of buildings.
I guess what I'm seeing is the key difference between this heritage rule and the hazard rule is where the hazard rule only applies where it intersects with the site, whereas the heritage rule would apply to the entire site. Is that correct?
To the entire site if it's scheduled and
Yes.
listed in the plan, yes.
And the Group A and Group B heritage listings, is that the basis for, what did you call it? Heritage A and Heritage B earlier.
No.
Yeah, well, so we've got Mr. Voster and Mr. Beaumont, but yet the Heritage A, B and C is more, that's the specific, whether it should be the 8 metres or the 11 metres, and they could better speak to this, but I understand whether it was an A or Schedule A or B heritage item was a factor in their assessment, but that it isn't a direct replication into, therefore, the provisions are Heritage A, B, C. Yeah.
Okay.
But it might be something they could speak to from their analysis.
My understanding was that they basically went site by site and say, this is a site that could stand 11 metres next to it. This is a site that could only stand 8 metres next to it. And it was that kind of forensic analysis.
Yes, it's a detailed, a specific analysis. They can certainly speak to that. They included site visits, for instance, to look from the at the adjoining
So
sites.
whilst whether it was Group A or Group B might have had a bearing, it wasn't the sole determination of whether an 8 or 11 metre height limit applied.
No, they'll step through that. They had a very comprehensive methodology as to the different factors that they considered, and that would have been, as I understand, one of the factors.
Mr. Recklin, while we have you in front of the screen, I wondered if it's worthwhile having a look at the site on the Mungavin east of Mungavin interchange, because that's an area where Mr. McIndoe and Mr. Ray have looked at maybe increasing changing the zoning to high residential, and that also has the Mungavin heritage site there. I can, yeah.
Mr. McIndoe?
Yes. Just to clarify, despite the Kainga-Ora submission to change the zoning to HRZ, we agreed it should stay, from our perspective, at mixed-use zone.
But with a higher height limit.
But with a higher height limit, which we thought could be an overlay of some kind suitable suitably.
Right, okay, thank you for
written.
that clarification,
Yep.
but I'm still interested to see, this might be a good example before our heritage experts arrive, to see how the heritage height layer works. It's the one where you're just north of that,
This
I
one
think,
here.
yes.
So my understanding, that's actually a scheduled heritage site. So it goes back to the rule that governs that heritage site are the ones I listed. So I'll just need to go back to that chapter. So they limit things like the number of any new buildings rather than the height of that
Right,
building.
okay.
So the trigger is, because it's a scheduled heritage site, is a new building is what triggers
Right.
that.
And what about the height of built development on the boundary in terms of, because I think it's the setting that is also part of the heritage listing.
So that would be, for example, this site here. Would that be, if you increase the height to 36 instead of the 22, would that need some further? Let me just pull up. So that's not currently subject to any specific height limitation controls, that particular site. But I think the point you're perhaps getting at is that might be okay for when it was 22 metres. But do you need to look at it again at 36? And I think that could well be something that
That we should ask the heritage
Yes, with,
witnesses.
and
What's the address of that so I can find it again? Can you just...
so that particular property where we could be seeking the extension
Mangavin Avenue.
is 1 Mangavin Avenue.
and I assume that would apply to wherever else other changes have been made, that somebody's gone back retrospectively and looked to see whether there's any change to the shading or heritage
I
height
think
or
yeah, in terms of the shading,
site-specific.
Mr. McIndoe is familiar with it and made the recommendation. But I think the point is other experts haven't had the opportunity to look at that in order, and that's, I would accept that is a step that is necessary.
Yeah, so that would be for heritage and for site-specific
That's
Maori
what-
and
yes.
anything else that...
But I'd say not for shading, because that's already
Right,
been
okay,
accounted for
sure.
by Mr. McIndoe in terms of
He would
arriving
have thought
at
of that.
his-
He would have thought about that when he sat down with Mr. Ray.
I'm assuming that's correct.
Are you nodding?
To be honest, I cannot tell a lie. No, we didn't think of shading when we looked at that. Okay.
It's got some more work.
Sorry,
for it.
we didn't think of shading in relation to heritage. We certainly thought about shading in relation to height, in relation to boundary, which applies at the boundary of the mixed-use zone.
So it's not, it wouldn't be the subject of a shading control in the sense that Mr. Rackling's talked about, that you modelled, that you spat out of your model, but it might be the subject of a reason for an additional heritage control, heritage-related control, which is obviously out of your field.
Correct.
Now, any more sort of explanations? Flowing out of Mr. McIndoe's joint witness statement with Mr. Ray, Mr. Racklin, the next question for you is, like I only read it at lunchtime and I haven't got my head fully around it, but it seems that from an urban design perspective, Mrs. McIntyre and Ray agree that the current large format retail centre zone north of the metropolitan centre might be metropolitan centre. What's your planning view in light of that development?
That was going to be one of my updates as part of the commercial.
Okay, forget that. Yeah, we'll worry about that at commercial.
Okay,
Or
because
unless everyone's bursting to find out. I think we can wait.
Okay.
One thing at a time here. Do you want to fire into it, and I'll chip in? Do it the inverse way, and I'll tell you if I've got something in front of you. Or do you just want me to go? Mixed use zone. So. So in terms of your supplementary statement, my understanding is that you've changed your position on figure 9.
That.
Figure 9, figure 13, which we've just been talking about. Based on Mr. McIntyre's advice.
That's the Kenepuru height limit.
Yep.
So, yes.
Figure 9 is the Kenepuru one.
Yeah, so that one, based on that, his assessment is where I would recommend the change in the height limit together with the change in the zone objective to account for it.
Similarly, 13.
Yes, so the community corrections facilities in the general industrial zone, yes, I accept Morrisdale's evidence on that.
So can I, sorry, Mr. Chair, on figure 9, that's not just a change to the height, that's a change of zoning, isn't it? At Kenepuru.
It is, that's correct.
Yes, to high residential zone from medium.
Yes.
Thank you.
And figure 13, as you just said, is to an RIP.
When you say figure
13?
Is this in my supplementary?
No, I'm looking at your 42A report.
Ah, sorry.
Like I'm just making sure I mark up
Yes.
which ones have shifted.
Okay, so you just had a plain catch up. So when you say, what page are we on?
Page 30.
30. So page 30 is the one where in my supplementary I have changed my mind. So yes, that's correct.
The next question, I know, no, won't go there. We'll deal with consequentials. I don't know whether it's just by printing, but on your figure 15 through, probably is, 19, the colours also, a lot of the colours seem to be amiss, but can I presume that wherever you've got a block of colour, that's the complying pedestrian network? So figure 15, you've said showed in red, and all I'm seeing is green. Don't think I'm colourblind, or not yet.
No, the red is, and this probably will come out. This is like a snapshot from the GIS layer. So the red line, if you look within the green blob, there's a red line. That is the pedestrian network. So that is within the 400 metres. So that captures the land in the green. So the line in the red is actually the pedestrian network by which you can identify if it's within the 400 metres.
And that the green area is effectively the area that's accessed from that pedestrian network.
That's correct.
Got that. Just in the rezonings, just looking. Yes, sir. Going to talk to you about St Pius's Church. An issue that Mr Warburton's raised about the extent to which its existence should or shouldn't be taken into account. This is your page 41. Is your logic that it currently, like it should be taken into account because of its current availability, or because of the potential that it will offer more non-faith places to the local school children?
One of the reasons why we chose primary schools is that they're a physical resource that's difficult to replicate, i.e., given their land take, they're going to be hard to put new schools within existing urban footprint. So they become a key resource. So that needs to take a balance between, yes, at the moment, it does prevent a large number of people being able to use it. But then looking at over the next 10, 15, 20, 30 years, that is the only school there. It's unlikely that a new school will be built within the existing urban footprint. And so their admission policy or the zoning policies that they have may change over time. And so this is one of those ones where I think that the balance is towards the potential future state rather than just what's the here and now.
Okay. Now, taking the contrary view, if we were to agree with Mr Warburton's view, do you consider that his map of consequences is correct about what would be excluded on that basis?
I've got no reason to doubt it, but I've not tested it, whether that's how accurate that is. But it looks at first blush to be down to cadastral level, so I assume it looks like it's been based on some sort of GIS modelling.
If you go to page 45, your figure 32, don't know if you can put that on screen, but where's the olive green line? It's all pink to me, or purple.
The green or stroke beige line is it's
Is that the thick line at
the bottom, so below the building and where the car park is. It's along there.
right now? The going to page 40. Lots.
I'm way before.
Oh, well, in that case, I see Mr. Bauman's here. Is Mr. Vossler on the line too? What's that? Just Mr. Bowman at the moment? Oh, well, well, why don't you go and more the merrier.
Sorry, Mr. Rackland, I wasn't keeping up very well there, and I want to take you back to page 32. Which is dealing with these planning maps and extension to the HRZ. At paragraph 129, you talk about the Kaingaroa submissions to extend the HRZ in two locations, Elston and Mana. The first one, you make the point that that really Kaingaroa are relying on the metropolitan centre zone being extended northwards to actually therefore extend the area of influence. And you've then pointed to the fact that you've addressed those submissions earlier in this report and you've recommended against that extension. If the committee finds that the panel finds that the extension is warranted, what does that mean for the that's the extension of the metropolitan centre zone? What does that mean for the extension to the HRZ?
Maybe I should, because that's the update I was going to provide tomorrow, but maybe if I let you know what the update is now, because these things are so interconnected. So
Yes.
based on the joint witness statements from the urban design, my view is that just make sure correct, is, yeah, so from the urban design joint witness statements, so I think that the weight of evidence actually now supports the rezoning of this land to the north of the city centre to metropolitan centre zone. Giving it a little thought beyond that, this would be, in my view, should be subject to a precinct overlay or some sort of controls to enable drive-through activities as a permitted activity within this precinct, but not in the wider metropolitan centre zone, i.e. if like the core of it. Limit building heights to 22 metres, but I do stop short of recommending it be rezoned through this process. And I do so because of the cultural significance of the harbour, and also, going back to your question then, Commissioner, the extension of the HRZ
Yes.
over Takapararia.
Yes.
And I just think with the cultural significance, whilst, yes, there has been a chance for Ngāti Taura to engage through submissions, further submissions, we know they have a further submission opposing in the PDP the extension of the city centre zone.
Yes.
So, yes, they've had the opportunity through Variation 1 to come back in, and we have had no evidence. But I think that needs to be viewed in the context of there are a number of these processes happening across Wellington, and I just think the Ngāti Taura would have been stretched to be able to fully engage in some of these changes that are coming
Yes.
through other submitters.
Yes.
So whilst I think in principle I can see now the merits of the rezoning. I am uncomfortable with rezoning it through this process.
Yes, but a middle ground such as a precinct that you talked about earlier might be appropriate.
So
I thought you said that you might consider, though, some sort of precinct instead of a zoning extension.
no, that was to have the zone extended, but a precinct over that part, so over what's called the large format retail zone now. So it enables drive-through activities in the metropolitan centre zone in that location and that location only, and it limits the height limits to 22 metres and not 53.
But like, I'm a bit puzzled. Are you saying that it should be rezoned now or not?
No.
And even if in a future process it was rezoned as a precinct, isn't there already a precinct underneath that?
No rezoning.
And there's an existing Whitireia precinct?
So you'd have two precincts.
Can I just clarify where we landed, because the Commissioner's just put to me his interpretation of what you just said. When you say not rezone now, do you mean the metropolitan centre or the HRZ, or both?
Both.
Okay. Okay, well, we need to see that in writing, because, I mean, you've only had benefit of the joint witness statement since Friday, I think. And
Well, probably this morning.
this morning. Yes, likewise.
So I could either do that as a follow-up to, I think, Chair, you indicated you're going to be providing some questions for responses sooner rather than later, or I could follow it up in more detail in the right of reply. So what I did was respond to what I saw and why I felt there could be a movement, but I still...
Well, I wonder if we should ask you to think about it overnight and give us not your final view, but a more considered view than you've been able to have from this morning, and then we'll go from there.
And I think that's important because Kaingaroa are presenting next Monday, so...
or Tuesday. Next Monday, you're right.
So it's important they hear what you've got to say.
And could you walk us what communication, if any, has been had with all of the commercial people who currently have businesses in the large format retail zone? You can include that in what you're talking about later. Yep. So have they had an opportunity to participate in this process and that sort of thing?
They have through, because clearly there is on the table a submission from Kaingaroa on this, that they've had the opportunity through a further submission to come in. I don't believe, other than the Ngāti Toa one, that we've had any.
Harvey Norman have made their own submission, haven't they?
They are seeking the rezoning to city centre zone, because from the PDP.
Oh, yeah.
So I would take that to mean they actually also want the rezoning to metropolitan centre zone.
Well, I wonder if we should stop there as I ask you to think about that and advise a more considered view. I'm not necessarily a final view. Like even tomorrow morning, it's not a lot of time to consider all the moving parts in this particular little conundrum. And we should pause there and bring in Mr. Bowman and Mr. Vossler. Gentlemen, welcome to the hearing. We've been working through matters about residential zoning, and in particular, we've sidled up to the question that's the subject of your evidence, which is controls over sites adjacent to heritage sites. We have your evidence, we've read it. Is there anything you want to highlight in your evidence before we kick off?
No, Mr. Chair. Yeah, we'll just take her evidence as read.
Well, any takers? Everyone's just thumbing through piles of paper here.
I'm not sure if you were both here when we were talking with Ms. Racklin and Mr. Racklin about these heritage sites that are adjacent to or within a zone where there might be a variation in the height limit to reduce the effect on a particular heritage site or area. Could you just briefly take us through how you went about that process?
Yes, so the process that we, the process we undertook to assess, I suppose, firstly, the degree of effect and then the significance of effect is sort of set out in paragraph 10 of our evidence. And effectively in that sort of it involved firstly a desktop analysis, which sort of looked at a number of attributes. So things like topography, zoning, the proposed intensification or density standards on adjacent sites. And this was followed up where we came to a view that there was the potential for there to be an adverse effect on a heritage item. We undertook field verification just to ensure that we understood the context in relation to both the item and its adjoining sites, and to get a better feel for what might be appropriate or what would be the necessary extent of any variation from what was being proposed in variation 1 in terms of density standards.
Thank you.
Mr. Vosler and Mr. Bowman, I don't know if either of you were present when we were discussing the a potential change in, in height requirements, in height for land to the south of Mungavin Homestead.
Sorry, I didn't hear that discussion.
Nor did I, sorry.
Mr. McIndoe and Mr. Ray, in their joint witness statement, have, and let me get this right this time, have agreed that a 36-metre maximum height is appropriate at two identified areas at the corner of Kenapuru Drive and south of Titahi Bay Road. And so on the plan, they're shown as two hatched areas, or in our, Mr. Racklin, Ms. Racklin, can you put me right as to where we might find those two maps?
Just to clarify, we're talking about the land east of Mungavin.
Yes.
Interchange. They are on my supplementary evidence.
I wonder if the best way is if you could put them share them on a screen that Mr. Bowman and Mr. Vosler can see exactly where you talk about, so we make sure we're not at cross purposes.
Just looking at Jack to assist me in this technology of how do I bring up maybe my supplementary
so
that I can share it.
Yeah, the site would be number 1 Mungavin Avenue, because that's the one next to.
Yeah, so maybe if we can bring up.
I'm sorry, I know this is a little bit complicated, but we're interested in your reaction to the
whether that would cause you, for instance, to reopen the result of your desktop analysis.
Right. Yep.
So is this the site of the Balmoral Motor Lodge or Belmont Motor Lodge?
Yes, I think it's the property directly south of the heritage site.
Yep, that one.
That one, yes. Do you have that on your screens?
Yes.
Yes.
Okay.
Yeah.
So the proposition in the joint witness statement was the agreement that a 36 metre maximum height is appropriate in that area.
And if someone could just please take us through what's proposed at the moment in terms of the maximum height on that site.
Our experts are just conferring in the
It's all in the IT app.
the IT out, yes.
I can answer that. Commissioners, I can answer that question. Well, that's currently zoned, proposed to be mixed-use zone, 22 metres in height.
So the proposal is that it increase from 22 to 36. Is that correct?
That's our understanding.
Yeah. Yeah. So I suppose just sort of reviewing the initial sort of assessment that we undertook on that property. What led Ian and I to the conclusion that it was unnecessary to actually sort of look at modifying what was proposed in that sort of in variation 1 on the adjacent sites was the location of the item relative to the boundaries. So to the south, we were looking at, I think, Ian, it was approximately 60 meters separating that southern site from the item. And it was around 45, 46 meters sort of to the east. So and given the fact that the building or the item was elevated on an elevated position, we sort of felt that it would be unnecessary in that to modify sort of what was proposed within variation 1. I suppose given the fact that we are now talking about an additional, 14 meters, we still have the distance factor. We still have the fact that the item is elevated, which provides sort of mitigating circumstances, I would have thought. Ian, have you got a view on that?
And there's sufficient buffer there in terms of vegetation, assuming the vegetation is retained. So we're going from, let's see, 5 stories to 9, 22 to 36 metres, is that correct?
Mr. McIndoe, can you confirm, is that from 5 stories to 9 in your...
The 22 metres should allow 6 stories, and the 36 should allow 10. So it's from 6 to 10 for residential development. It would be different if it was commercial.
Thank you. Did you catch that? From 6 metres to 6 stories to 10 stories.
Yeah.
Yes, I did, thank you.
So is the message you're comfortable with either way? The additional 14 metres wouldn't alter your assessment?
From my perspective, I think, there probably is sufficient of a buffer. So what we're wanting to avoid is domination of heritage item, and 60 odd metres separation, I feel, wouldn't cause domination of the heritage item. Other criteria we looked at were what kind of visual catchments might be impacted, what kind of vistas and sight lines, and the site to the south, I don't feel would impact any of those kind of qualities or issues.
Mm. Yeah, because the other mitigating factors are that, you know, sort of to the east, to the north, it's bounded by open space zone. So it's sort of thing that it wouldn't be, or as a consequence of what's proposed by Variation 1, it wouldn't result in the item and its setting being enclosed by more intensive development. So once again, you know, sort of the fact that there will be sort of unimpeded, you know, sort of views and outlook and, you know, sort of lack of development and that sort of to the north is also a mitigating circumstance.
Do you mean it wouldn't get bookended, essentially, by development?
Yeah. So effectively, the item wouldn't be bounded by, you know, sort of much more intensive development. So what we're conceivably saying, if the panel was of a mind to proceed with what has been agreed through conferencing, is, you know, sort of effectively 10-story to the south. You would have then, what is it, sort of 4 to 6 stories to the east, but to the north and west, there would be no development, well, certainly not any development of that order.
Thank you.
Any other questions for these gentlemen? Go for it.
Good morning, good afternoon, Mr. Bowman, Mr. Vosler, David McMahon here. I'm just interested in the initial desktop analysis that was undertaken to determine the application of Heritage A, B and C type delineations. I note that one of the factors in the desktop was the heritage category that applies on the site, and I just wondered, noting that there are other factors that the desktop assessment took into account, how determinative was the heritage categorisation in your findings? Was the difference between a category A and a category B matter a significant factor, or did the local topography and site area and other things like visual connections dominate the assessment at the end of the day?
Yeah, I think there, David, and that's sort of the foundation, if you like, and that sort of our assessment was the impact on values, you know, sort of irrespective of whether or not they were category A or category B.
Yes.
Statement of significance within the associated schedules within the PDP sort of outline in that sort of what the associative values are in relation to all the places that we assessed. And what we were most interested in is what the potential impact might be on those values of the level of intensification or degree of intensification that was proposed via Variation 1. So in that respect, it was more geared towards sort of a values assessment rather than saying, okay, this is category A, it is more important,
yes,
and therefore we should be looking at perhaps not sort of any proposed changes to the, you know, sort of the intensification or standards and that sort of that they should be modified accordingly. So it was really looking at it from the point of view of what were the set of values that were potentially impacted by what was being proposed.
Thank you for that. I have a follow-up question, but before I do, Mr. Bowman, did you want to add to that in any way?
Just to explain that that's illustrated graphically in the table in our evidence, Appendix 2.
Yes.
So heritage values are identified, and whatever impacts there might be on them.
Okay. The reason I asked that question is that the difference in categorisation is reflected in different policy provisions when dealing with alterations or additions or demolitions to scheduled heritage items. So clearly the difference in categorisation has quite a significant policy difference when you're dealing with a direct effect on the heritage item. But in this case, where you're dealing with building heights and height in relation to boundary on adjoining sites, it's quite a different consideration then. That's what I'm hearing.
Yeah. Okay. So we're not, I suppose there, David, the distinction is we're not talking about what's happening within the site.
Yes.
We're talking about what happens external to the site.
Yes. Yeah. I completely understand. And thank you for that clarification.
I think we're good to go. Thank you, gentlemen. Thank you for joining us this afternoon. Appreciate that. Just ask Jack, we're expecting the retirement team at 1:45. Are they going to be here in person? Okay, well, can you see if they can start at, say, 22, and we'll go from there. So we'll adjourn till 22 in the hope the next minute might be available to go, and if not, we'll restart when they're ready. Thank you. Have Dr. Mitchell, I can see in the distance.
Thank you. Thank you, sir. I'm just going to close my blinds behind me because there's a bit of glare. Just excuse me a moment.
So, Mr. Hinchy, we have Mr. Collins, Mr. Brown. Pull up a pew and make yourself at home. Representatives of Ryman Healthcare Limited and the Retirement Villages Association of New Zealand, Inc. Mr. Hinchy, how would you like to proceed?
Sir, we've got some legal submissions that have been lodged only in the last couple of days, and then 3 briefs of evidence which were lodged a week or so before that. On the basis that the legal submissions have only just come to you, I was contemplating reading some of those out, and perhaps just not all of it, but touching on some of the key points. And the intention was for Mr. Brown and Mr. Collins to present a summarised version of theirs, and then Dr. Mitchell will address his evidence and probably pick up any questions and things like that that have come up throughout the session, rather than reading off the script, as it were. Are you happy for us to proceed on that basis?
I think that you can take it as a given. We've read your legal submissions, Mr. Hinchy, so don't feel the need to, I trust you won't feel amiss that they seem remarkably familiar to some of us.
I thought you might say that, sir, and I was hoping that we were consistent, at least with the last time we came before you. So I might touch on a few themes, if that's okay.
But you should touch on anything you regard as important for the benefit of our colleagues who didn't hear you 2 weeks ago.
Indeed. And I might introduce the team as well, if that's right, because I understand a few of the commissioners may not be familiar with our team. So I'm Luke Hinchy. I'm legal counsel for the Retirement Villages Association and Ryman Healthcare. And I'm also legal counsel for those parties in relation to all of the other Tier 1 council processes that are doing the same thing as Porirua. And I'll just hand over to Mr. Collins and Mr. Brown to introduce themselves.
Hi, my name is John Collins. I'm the Executive Director of the Retirement Villages Association.
Thank you, Mr. Collins.
I'm Matthew Brown, General Manager Development New Zealand for Ryman Healthcare.
Good afternoon, Commissioners. My name is Phil Mitchell from Mitchell Dash, Planning Consultant for the submitters.
All good.
All good. Okay, so I'll just perhaps take you to my written brief, and as I say, I'll just touch on a few points as we go. I'm happy to answer questions as we work through things, or at the end, Mr. Chair, whatever suits the panel. At paragraph 2, I just make the point, which is summarised in the evidence to follow, that between now and 2050, the population aged 75 and over in Porirua is forecasted to more than triple. However, the shortfall of appropriate retirement housing and care to cater for that population is already at a crisis point. And delays and uncertainty caused by RMA processes are a major contributor. So this legislation and I guess the processes it prescribes are seen as a significant opportunity by the retirement industry to address all of those challenges. At paragraph 5, the submission is that the proposed and operative district plans do not adequately provide for retirement village development in Porirua. The plan changes go some way to recognising retirement villages as a separate activity category, but the regime is not submitted to be fit for purpose, and other aspects of the plan go beyond the policy directives and accordingly over-regulate. Accordingly, it's submitted that the plan changes as they relate to the industry submissions do not appropriately give effect to the MPSUD, and they do not implement the directions of the enabling housing legislation. Some specific features that are worth just highlighting in 6.1, 2 and 3 that come up in this particular hearing that we'll get into in a bit more detail shortly. Firstly, retirement villages need to be seen as a residential activity, and the ancillary activities that go along with retirement villages are part and parcel of that activity, and I'll come back to the case law on that in a minute. There are some unique internal amenity needs of retirement villages which make them different to other residential activities, and they primarily relate to internal layouts of units, the shape and size of them, their access to outdoor living space, their outlook and things like that, which Mr. Brown and Mr. Collins will explain are necessary just essentially to provide the appropriate care needed for the residents in those types of units. And there is a functional and operational context to retirement living. There are different layouts to allow for amenities and facilities that service the needs of the residents. There are also different sort of layouts to ensure that people can get to and from spaces conveniently and safely, which are probably different from what you see in a multi-unit residential development. And often a lot of the main activities of a retirement village are provided for in one central building. So that building tends to be more of a sort of apartment style building, which may be bigger, and bulkier than the sort of the likes of your typical townhouses and single houses in the surrounding neighbourhood. So there's just a couple of the sort of functional operational requirements that are different in a retirement village context, which Mr. Collins, Mr. Brown and Dr. Mitchell cover in a bit more detail. And then over to paragraph 10, the legal framework. I won't go through this in detail because, Mr. Chair, I know you've read this extract before, and others on the panel have already read this too. But I just wanted to, I suppose, touch on the first sentence there at the outset. It is important to acknowledge that the primary purpose of this process is to address New Zealand's housing crisis. And as noted, and as explained in the evidence, retirement housing is having its own unique crisis, and that's because demand for retirement village accommodation is outstripping supply as more of our ageing population wish to live in retirement villages that provide purpose-built accommodation and care. And then over at 18, again, emphasising a point I've made in the previous hearings, that this process is not about providing the bare minimum to respond to statutory requirements. The task is a very important one. The IPIs and the ISPP are a means to solve an important and national housing issue. And we respectfully submit that overarching legislative and policy context, the NPSUD and the Enabling Housing Act, the purposes of those to address New Zealand's housing crisis, accelerate housing supply, and remove planning restrictions is something that should resonate heavily in all considerations through this process. Paragraphs 21 onward deal with some of the concepts from existing RMA Schedule 1 plan making processes, which will no doubt be familiar to you all. I've just highlighted a few case references there around the idea that, we're essentially a planning regime can be met by a less restrictive regime, that regime should be adopted where it's obviously in accordance with the purpose of the Act and the other statutory requirements. The RMA is not drafted on the basis that activities are only allowed where they're justified. Rather, the Act proceeds on the basis that land use activities are only restricted where that is necessary. And then some case law around the fact, when you've got alternatives, the council's version versus, in this case, the submitter's version, there's no presumption that the council's version is the correct one. That needs to be looked at carefully. And if there are other ways of addressing the same, outcome, and that's been raised by evidence, as it has in this case, then the decision maker should look at other possibilities, and that's derived from Section 32, as you know. I've sort of worked through the NPSUD provisions in the following section of my submissions. I won't read that out. I guess from 29 onwards, there's the concept of the NPSUD being an enabling document, and that's sort of, I guess, reflected in the ministry descriptions about it. And then there's an evolution there in terms of the NPSUDC, which was the prior version of the current NPS, and some case or the Bunnings case that talked about what that meant in that particular context. And I've submitted there that you can apply that same sort of thinking here, albeit that this particular NPSUD has essentially gone further than the previous one in building on many of the concepts, and I guess having a wider focus and adding significant new and directive content. In terms of paragraph 35, well-functioning urban environments, probably just some wording emphasis there. Dr. Mitchell's covered these provisions in more detail, but you're talking about enabling all people in communities to provide for their wellbeing and health and safety. Obviously, the all being in our context that older demographic, enabling a variety of homes to meet the needs of different households. Again, that's very pertinent in the context of retirement living, and then enabling more people to live in areas that are in or near centre zones and so forth. Paragraphs 36 to 40 are talking about that expectation of urban environments changing over time and plans being responsive to enable particularly significant development capacity. And that's obviously part and parcel of what we're seeking here. And then turning to 42, in terms of the plan change itself, the regime that Ryman and the RBA are seeking is a more enabling and responsive planning framework for retirement villages. And in that respect, Ryman and the RBA are supportive of some aspects of the reporting officer's position, for example, acknowledging that the policy should provide for benefits for retirement villages, design guides are not appropriate for retirement villages, and that internal amenity controls of typical residential units should not apply. Of course, there are some differences of opinion in terms of what the regime should actually look like, despite those sort of broader agreements. Then it's probably just worth touching on, I think, where one of the key differences between the regime that the industry is promoting versus what the council officer considers as appropriate. I respectfully submit that difference, or particularly where the material differences lie, are related to a misunderstanding of what retirement villages actually are. And I made the point earlier that retirement villages are a residential activity. So that's one of the key things where the officer has misinterpreted that, what that use is all about. I talked to those functional, operational, other needs, and then there was a comment, perhaps not a major one for here, but in terms of whether there's any Section 32A evidence to support the industry position. I'll touch mainly on the first two points. In terms of the retirement villages are a residential activity, Mr. Chair, I have addressed you on this topic and it was asked some questions in the last hearing in Wellington for the benefit of others on the panel. The submission here is that retirement villages are very much a residential activity, and all of those ancillary activities that go along with the retirement, which are for the residents, are part and parcel of that. In the earlier hearing, Mr. Chair, I mentioned the Hawkesbury case as one example where the High Court's engaged on that issue of whether those ancillary activities are still residential in nature or whether they essentially become commercial or some other type of use. We've done some further research and found another High Court case, a more recent one, which interprets or applies the thinking in Hawkesbury and takes that, I suppose, further in the context of the particular proposal, and again engages on that issue about whether the ancillary activities that are associated with the retirement village can be seen to be part of a residential activity. The case there was in the context of whether the residential activity definitions under the Amendment Act, which has now been repealed, applied, and it was important in that case because if it was a residential activity, then appeal rights were restricted, and if it wasn't, then clearly people could take things on to the Environment Court. But as I say, the Environment Court in that case, having worked its way through the logic of statutory interpretation exercise, reached the view that ancillary activities like pavilions, recreational facilities, meeting places, all of those things are inextricably linked to the definition of dwelling house and therefore part of that residential activity. So we say the same situation applies here, and to some extent that is essentially baked in through the definition of retirement villages itself, because it talks about retirement villages being accommodation for people, and then it talks about those ancillary purposes or activities.
I think we've lost them. Lost, potentially, since the screen's frozen.
Cut off in mid-stroke.
Yeah, it's the same one that's been used in this case.
Is that Mr. Hinchy?
Yep.
We lost you for a minute there, so your words of wisdom for about the last 3 minutes went into the electronic void. So,
Okay, sir. Well, that's
you were talking about the Ngāti decision when you went very still.
okay. Well, I'll try not to repeat myself, and I'll try not to say things I had already said. So where I was just getting to, I think, is that in the previous case, sir, I talked to the Hawkesbury case and the High Court decision around the whether or not ancillary activities associated with retirement villages were essentially part of the residential use or whether they were some sort of separate use. We've done some more research on that and discovered this other new case, which essentially addresses a similar scenario where there was a question about whether all of those ancillary activities associated with the retirement village use were, I guess, part and parcel of the dwelling house or the residential use. I mentioned that the context was a bit different in that case because it was essentially the Environment Court grappling with whether an appellant in that case had appeal rights because I don't know if you can recall, but the Amendment Act, the Resource Management Act at one point restricted appeal rights where activities related to residential activities. And this was one of them where a retirement village was seeking to take the benefit of that regime, and that the appellants in that case were seeking to say that they weren't residential activities and that would then give them appeal rights. But of course, the Environment Court in that case, upheld by the High Court, said that it's essentially all of those ancillary activities are still associated with the main residential use.
Mr. Hinchy, can I ask a question, Commissioner St Clair here? Just in terms of the ancillary activities for residential, where does that sort of start and finish in terms of for retirement villages where they're providing almost like hospital care? Is that also part of the residential activity and what you're seeking, or is there somewhere a spectrum, or what is it?
It's probably worth having a look at the definition of retirement village, and I'll just read it out in case you haven't got it there in front of you. But it means a managed comprehensive residential complex of facilities. So it's comprehensive, it's a residential complex, it's used to provide residential accommodation for people who are retired and their spouses and the like. And then it says, importantly here, it may also include any of the following for residents within the complex: recreation, leisure, supported residential care, which I think is the example you were talking to in terms of, hospital type provision, other care services, welfare and medical facilities, and then bracket inclusive of the hospital care, close bracket, and other non-residential activities. So the definition wraps up all of those concepts in this sort of, I guess, subcategory of related activities to the main accommodation use. It may be worth exploring that question, Commissioner, in terms of what hospital means in the context of retirement villages with Mr. Brown and Mr. Collins, because I think it's probably a fairly typical misconception that a hospital bed in a retirement home is the same as the hospital bed you might find in a in a public hospital. I think the opposite of that is true, in that people who live in hospital units in retirement villages essentially are there for the long term. They consider those units to be their homes, and it's not very much like in the nature of a hospital, which is has the comings and goings, and it's a much more medical based type facility. But I might invite you, if you feel the need, to test that out and tease that out a bit with Mr. Brown and Mr. Collins.
Thank you.
And then I just talked in the submissions to that point around the definition. I'm just saying there that there's a direct link, I suppose, between the two High Court cases I've referred to and then the way that the definition applies, because the definition of retirement village, I say, essentially requires those ancillary activities to be for residents within the complex. And I think that's a really important phrase. To the extent that a retirement village operator is seeking to provide something which is not, for the residents within the complex, then they may be drifting into another activity category, but that's not the general proposition.
Sorry, does that mean that the hospital care part is only for those people who are within, say, an individual villa or an apartment and they move to the hospital level care? Or does it mean that somebody from outside the retirement village can come straight into hospital care?
I think it's both. I might just throw that one to Mr. Collins and Mr. Brown. If that's okay, Commissioner, they'll be better placed to give you some technical advice on that.
So generally speaking, the supported residential care, which is what the hospital care might be in a retirement village, for us it's a care centre, which is as I just said, supported residential care. So that the terms rest home, hospital, or specialist dementia, they are really just referring to the different levels of support that our staff might provide to a resident who's living in that care centre. So generally speaking, the care centre is there as to provide that level of care and support for residents who've been living in the retirement village. And that's not to say that from time to time people do move into the care centre from outside, but generally what we're building is a comprehensive care retirement village, and so predominantly the care we're building is to provide that level of supported living for residents who whose needs require it after they've been living in the retirement village.
And do people who live in the supported care facilities, is that all on an individual room?
Yes,
So
yes it is.
So it's not like a hospital where you turn up and there might be 4 beds in one unit.
No,
they're all
each
individual.
yeah, because it's that person's home.
Right, so it's regardless of the level of care, they all have at least one.
That's right.
Room. Okay.
Yes.
Thank you.
Yeah, and so we were going to actually send in a memo just inviting the panel and the council officers to undertake a site visit of a selection of retirement villages in the Wellington region, if that would assist, because I think once you sort of see the model and the type of environment that people are in, some of the points we're making, I guess, become clearer. So I'll put in a memo in due course to offer that invitation if you wish to take it up.
I think in Commissioner Sinclair's situation, he spent a lot of the last 12 months in a retirement village environment.
I'm probably okay on the site visit, thanks.
So you'll probably pass on the site visit.
All right. Well, some of you may wish to take it up. It's up to you. You might get a cup of tea and a scone or something along the track too, just to sort of talk you into it.
You know the way you know the rules about bribing decision makers.
Any other guests would get the same treatment, sir. So hopefully we're okay there. So I guess just wrapping that up on the definition point, it does become very important if you accept the argument that a retirement village is a residential activity and those ancillary activities are sort of part and parcel of the main use, then that's where I think the council officers' view and their approach in terms of the overall planning position for this industry starts to get off track. The following section deals with clear and efficient consenting requirements, and I've probably just made a few points there, and again, just focusing on the things that the reporting officer perhaps hasn't appreciated. I think one of the points the officer's making is that because of all these unique and operational needs of retirement villages, there may be effects of different effects, and they may not be being managed appropriately by the regime that is being put forward by the industry. I think, paragraph 54, quite aside from the fact that there's no substantive evidence to support those assertions, we respectfully submit the officer misunderstands the RVA's and Ryman's proposed approach. Because as explained by Dr. Mitchell, the regime proposed by the RVA and Ryman is largely aligned with the planning approach for other residential developments involving 4 or more dwellings. So that's sort of the starting point for the regime. And then it has some necessary nuances, particularly for internal amenity controls, which better reflect on-site needs. And that the officer seemed to agree with that idea, but just not for the same reasons. All of the MDRS density controls that apply to manage external effects, which is the height in relation to boundary, setbacks, and so forth, all of those controls would also apply to retirement villages. So not seeking to exclude the retirement sector from those controls. And other areas where the officer considers there might be some potential concerns, for example, nuisance hours of operation, those sorts of things. Again, the industry doesn't argue that it should be excluded from, whatever the residential zone noise controls are, or any controls over hours of operation, if there are in fact any in the plan. We also submit that the officer's report suggests that the regime proposed by Rome and the RBA is not intended to create a situation where there's no policy direction for the assessment of consents. The policy and rule framework ensures that all of those things are appropriately and proportionately assessed. And then, I've set out at 56 some of the key features of those, and Dr. Mitchell will cover that in more detail. And then I suppose it's really just the difference of approach between, say, the officers and the retirement sectors. We submit that the restrictions that are proposed in the proposed plan, RESZ, P7 and P8, those restrictions just go too far, and that they conflict with Policy 5 of the NDRS by failing to provide for developments not meeting permitted activity status while encouraging high quality developments. I think that word encourage is important because if you go from beyond encouraging, where essentially you're either not encouraging or you're requiring certain things, then you're starting to fall outside what that policy expects.
So, Mr. Hinchey, so you don't want 7 and 8 to apply. Are you happy with policy 13?
Probably got me on the level of detail there, sir. That might be. I've got to kick that one down to Dr. Mitchell, if you don't mind, because I don't have that in front of me. But
I think the answer is no.
That's correct, Mr. Chairman.
Dr. Mitchell will tell us about it.
Right. Okay.
Yeah. So, and the regime is essentially we're still seeking controls over the sorts of things that a multi-unit development might give rise to in terms of effects, but doing that in a more enabling and less restrictive way. And I won't take you through the conclusion. That's all just taken as read. And I'm happy to answer any questions at that point or hand over to my first witness.
My question, really my only question, Mr. Hinchey, is whether focus on whether it's a residential activity or not is like a straw man, because the 42A report clearly accepts that retirement villages need to be dealt with separately. It clearly it's seeking to provide a separate policy. We can discuss with Dr. Mitchell separate policy. It's seeking to exclude retirement villages from internal amenity controls and focus on external effects vis-a-vis neighbours and general built form. Basically, I'm thinking, where's the problem? Why do we need to make a finding on what to me is a nicely academic question of law? Is it a retirement village? Because I'm thinking, well, so what? It's clearly a retirement village with special features. You tell us it's got special features that need to be provided for. As I say, are we just going down a legal rabbit hole?
Well, I think I probably was only making the point to say that, the officer, if they've started from the point of view that the activity is not a residential activity or contains components that aren't, then, the response that they've presented is more directed to that alternative type of use. So I guess I'm just saying that if get the starting point wrong, then it follows that the regime that you're promoting is potentially wrong as well. And I've made a number of, and Dr. Mitchell covered this as well, that some of the points that they then make are not appropriate. In terms of, I guess, the merits, it really, there's two ways to do it, I suppose, and of course there always is. we're saying essentially that the regime that we put forward is more proportionate, it's more effective and efficient, it's less restrictive, it's more enabling, all of those things which the NPSUD and the Enabling Housing Act are intended to achieve. And another element to that, I suppose, is that's been made in the evidence, at the point that's been made in the evidence is that industry is also seeking a more consistent regime for retirement villages around the country using its collective experience and sees a lot of value and efficiency around, councils treating retirement villages in generally a fairly similar way. So that I guess the subtlety between the two regimes, if you're sort of on the edge, I suppose, of should you go council, should we go with the retirement sector, then I would respectfully ask you to take that sort of efficiency benefit into account as well. In terms of the actual details of the regime, I think, they do at a principles level provide for retirement villages and do that in many ways in a similar way as one another. But I think at the end of the day, the officer one is not as good a fit, and I think does, as I mentioned, go further in terms of restrictions which shouldn't be applied in this new order that we're living in.
Okay, and you've emphasised the definition of retirement village. It says that associated facilities must be for the residents. It doesn't say it must be solely for the residents or even principally for the residents. Do you think that creates an issue? And we can't change the definition because it's out of the national planning standards.
Yeah, I mean, I think, Sue, you're right that there's probably an element of or lack of clarity there in terms of what that means. I think it's, as we talked about in the previous hearing, it's going to be to some extent fact specific in terms of the village proposal at hand. For example, the retirement village is there and there's a cafe on the street frontage which is clearly open to the public. The retirement operator tries to argue, well, it's for the residents as well, even though the primary purpose seems to be to service the public. Then that might be straying outside what that definition is intended to mean, versus something which clearly is internal. It's only accessible to the residents and their guests. It'll be a much more straightforward, part and parcel of the retirement village scenario. But I think you probably have to test that in the context of a particular case.
I think that's all I had. Any questions for Council? Should we hear from, gentlemen, who got the short straw and guessed to go first?
I think Mr. Collins might be up first.
Kia ora. Thank you very much. As I said, I'm John Collins. I'm the Executive Director of the RVA. I was appointed Executive Director in October 2007. I've been in the industry for 15 years. I have considerable knowledge and understanding of the aged population and the retirement sector and its challenges. I presented evidence to the RVA in a number of planning processes, including the Christchurch Replacement District Plan and the Auckland Unitary Plan processes. We sought and have successfully obtained bespoke planning provisions for retirement villages in those areas. I will briefly set the scene to our submissions, including the background to the RVA, the aged care and accommodation crisis, and what we need for the retirement village industry in the present process. The RVA is a voluntary industry association that represents the interests of the owners, developers and managers of registered retirement villages throughout New Zealand. Today we have around about 410 member villages throughout the country with around about 38,520 units that are home to around 50,000 older New Zealanders, slightly larger than the population of Upper Hutt. The RVA's members include all 5 publicly listed companies: Ryman Healthcare, Somerset Group, Arvida, Oceania and Radius Residential Care. Other corporate groups such as MetLife Care and Bupa, independent operators and not-for-profit operators such as community trusts and religious and welfare organisations. It's effectively 96% of the industry by unit number. The proportion of older people in our communities compared to the rest of the population is increasing rapidly. In Porirua, the 75 plus population is expected to increase from 2,470 people in the last census in 2018 to 8,900 people in the 25 years to 2048. This is a 260% increase compared with the general population increase of 21% in Porirua during this time period. It's probably worth noting that RV retirement village residents are active older people who are capable of living independently, compared with the residents of aged care who have varying levels of dependency. Some 65% of villages have some degree of care on site, so villages are generally designed to accommodate residential care as part of their campus. This growth in Porirua, combined with more people seeking out the high-quality care and amenities that retirement villages provide, will lead to an increased need for retirement villages. Our experience and data shows that demand for retirement villages is outstripping supply, and that this trend will continue to be the case. This crisis is evidenced by the increasing number of RVA's members' villages that have waiting lists of 2 or more years. Our members' experience is that older people want to stay in the communities in which they currently live and have lived for many years during their retirement. This is called ageing in place. It allows residents to remain close to their families, their friends, familiar amenities and other support networks. It allows residents to continue to play an integral part in the communities that they helped establish. To allow older people to age in place, it's important that district plans provide for retirement villages in all appropriate zones, including residential, commercial and mixed-use zones. RVA members are currently heavy users of the RMA process. Members rely on resource consents to authorise much-needed retirement villages and their ongoing operational needs. However, as our submission outlines, the RMA has caused a number of major challenges. Accordingly, the RVA and its members were greatly encouraged by the Resource Management and Enabling Housing Supply and Other Matters Amendment Act 2021. We see the present process as a significant enabler of accelerating housing intensification for the ageing population. I note that the RVA is heavily engaged in intensification streamlined planning processes across the country. As Mr Hinchley noted, we are seeking consistent provisions in all the Tier 1 cities, which we consider appropriately respond to the relevant statutory directions. Consistency is very important for certainty and efficiency. I also note the RVA has consulted heavily with its members to ensure the provisions we seek have a unified support across the membership. In Porirua, the key outcome we seek is to accelerate housing intensification for the ageing population in a consistent and enabling regulatory framework which clearly responds to the needs of an ageing population and the unique features of retirement village activities. We also seek to remove undue planning restrictions which are needed to better reflect the government's housing intensification requirements. Variation 1 and PC 19 have moved some way to addressing these factors, including by having a separate retirement village regime to typical residential housing. We're also encouraged by some of the proposed amendments in the Section 42 report on residential zones, for example, acknowledging that the plan's policies should provide for benefits of retirement villages, the residential design guides are not appropriate for retirement villages, and that internal amenity controls for typical residential units should not apply to villages. Council Officer also appears to agree in principle with many of the general themes of the submission, but thinks the plan already adequately addresses these matters. However, in our view, the regime is still not fit for purpose, and it appears the officer has some significant misunderstandings about retirement village activities and their residents. The officer states that retirement villages are not a residential activity. I strongly disagree. The primary purpose of retirement villages is to provide permanent homes for the residents that live there, whether that be in higher care environments or in independent living. People living in retirement villages will universally describe their village as their home. Ancillary services are provided for residents only and complement the residential function of retirement villages by meeting the particular needs of the older residents. Retirement villages provide most, if not all, of the resident amenities on site without the need for external community infrastructure or space. These services and amenities are important due to the frailty and lack of mobility of many residents. They also provide a better quality of life for residents than could be offered without these communal services. For example, a townhouse would be unlikely to have space for a pool or a gymnasium. A key consulting challenge faced by our members is an expectation from council officers that the internal amenity controls used for traditional housing types, for example, outlook, sunlight, privacy, outdoor living spaces, landscaping and the like, are appropriate for retirement villages. However, in our members' experience, council officers often attempt to redesign village layouts based on what they think might be suitable without proper knowledge of villages and residents' needs. In this case, the RVA is encouraged by the acknowledgement in the Section 42A report that such controls are not appropriate for retirement villages. However, we prefer the alternative controls suggested by Dr. Mitchell, which are better suited. I disagree with the Section 42A, which suggests that these features of retirement villages may result in greater effects. In our experience, retirement villages fit very well into their environments. They are peaceful and tranquil places, often including significant landscaping and open spaces. And these outcomes will be expanded on by Mr. Hinchley and Dr. Mitchell. Mr. Chairman, if no questions, I'll hand on to Mr. Brown.
Well, I do have a couple of questions, Mr. Collins. The first is about the graph in figure 2 of your evidence, which I was intrigued by.
Just have to bring that up. Figure 2, yes.
It may be a visual illusion, but it appears to be levelling off, i.e. that it's steepest from now until about 2038, and then slowly levelling off, just to my eye.
There may well be a slight reduction in the increase, but basically the demographic for the baby boomer population between now and early 2040s, when we will be in our 90s, is then taken over by the next generation of Generation X residents who are slightly fewer in number, but are still a significant ageing demographic for all that.
Can I ask a related question?
Certainly.
Ms. Collins, do you know that the people that are over 75, what percentage of those people live in retirement villages as to living independently outside?
It does vary a little bit from city to city, but nationally it's about 14% of the over 75 population choose to live in a retirement village. And that number has increased steadily over the last 8 or 9 years, from about 9% 8 years ago to 14% now, well, the end of the year before last, to be fair, which is when we're just about to start on the next survey of our members to get the most recent numbers. But so not only has the number of 75-year-olds in the population increased, the numbers of 75-year-olds moving into our villages has increased at a faster rate.
What is there anything magic about the number 75 plus that has that? What about, I don't know, people that are 65?
We use 75 as the number because the average age of entry is mid to late 70s. If you're 65, your decision to move to a village is often governed by external factors like yourself or your partner's health, for example, the availability of a village, those sorts of things. But we generally find that by the age of 75, many older people are starting to look for a security of finances, for example, or companionship, pathway to care, an age-appropriate, warm, dry place to live, all those sorts of things which villages provide.
Thank you.
Kia ora, Mr. Collins. Thanks very much for your statement today and for your original statement of evidence too, which has been very helpful. I'm just trying to get a greater sense of the demand for aged care facilities in the Porirua context relative to other parts of the country. And as you've been discussing already with my fellow commissioners, there are some interesting statistics here that relate to Porirua, and I'm interested in your views around how they compare to other parts of the country. So, for instance, at paragraph 5, where you have mentioned the 75 plus population is expected to increase exponentially to 2048. Representing a 260% increase compared to the general population. I'm just wondering, the general population, of course, in relation to Porirua, I should say, how does that compare nationally?
Yes, that's a very interesting question. The work which I did looking at the Porirua demographics suggests that younger people are a higher percentage of the total population in Porirua than it is, generally speaking, elsewhere. But nonetheless, we have, I think, 3 villages within Porirua City. One of those is reasonably new, and I know that their aged care facility is larger to accommodate more people from outside. Another one is in the process of building a new care facility, which won't be available for a few years yet, but is targeted mostly at their own residents. And the third one only has a rest home level care and is thereby a little constrained. So there is going to be a need for more development in the city, even though the population is on a whole younger.
So in terms of that 14% figure you provided just before, in terms of those who live in retirement villages nationally, are you able to give us the figure of the proportion of people in Porirua living in retirement villages now?
Oh yes, we did look at that.
Just at paragraph 60 of your evidence, John.
Main evidence.
Oh, I see.
Of the main evidence. Yep. And paragraph 39 is probably worth touching on in terms of the, 40 in terms of the numbers of people in the district at that 75 and 85 plus range.
Yeah, it was in the evidence then.
In the main brief, yeah.
In the main brief, yeah.
So that was paragraph 30 something?
39.
39.
39 and 60.
60.
60, yeah.
39 and 60. Okay. 39. Oh, yes.
3, yes.
Okay.
Home to 516 residents.
But it doesn't, does it tell us?
Paragraph 60 says 20%.
21.7% of the over 75 live in a retirement village in Porirua, which is higher than the national average.
Yeah.
But then the national average includes places where there aren't any villages at all. So it's
that's true.
So Porirua, there's 3 of them, and it's 516 residents. And that number will increase as the New Somerset Village finishes its development.
Oh, that's interesting. And just one final question there, because I'm interested in the unique context and demographic that exists here in Porirua, given the relatively high proportion of Māori and Pacific Island population, and I think we've got a growing Asian contingent there too. So I'm interested to know whether you have done any work in looking at the take-up of retirement villages by Pacifica and Māori people in particular, especially given that we tend to die a lot younger. And I mean, we have officially we have a shorter life expectancy.
Tragically so.
Yes. And also we have different cultural norms, of course, that create a greater impetus for whānau care of our elderly. So I'd be really interested in your views around that.
Yes, you're perfectly correct, Commissioner. The tradition of whānau care is and remains strong within Māori and Pacifica communities. Retirement villages generally tend to be quite homogeneous in their makeup. It is something which we are aware of. It's something which, in time, we think will evolve. In my personal view, is that I think we're seeing the last generations now of whānau care. We think that as the population becomes more dispersed, children live overseas in different places, the ability to look after older people at home, even if they may want to, becomes more difficult.
Yes.
And certainly as people live longer, then their needs become greater, and it's difficult for, even with the best will in the world, for whānau to look after really old and really quite ill people at home. So we would expect villages to become more attractive, and certainly we're seeing in other parts of the country an Asian population moving into villages. We've got a couple in Auckland where there's quite a strong Asian and Indian population moving in. So we will see that will roll through the country over the next 5, 6, 8 years, I would imagine. And Ryman's will have some as well, I assume.
One question from me, Mr. Collins. You said you've got 3 current villages, 1 in development. Where exactly are they?
The one in development is the Somerset development at Kinaparu. There's a Somerset development at Aotea, which is quite a mature village, has been there for at least 15 years, if not more. And the third one is Whitby Lakes, obviously in Whitby. And Whitby Lakes is currently a lifestyle village, but they have plans to build a 52-bed care centre on a land which they own adjacent to the village.
Thank you very much. No further questions for me.
Likewise, I think we're up to Mr. Brown.
Kia ora. Thank you, Commissioner. General Manager for Development New Zealand for Ryman Healthcare. I've prepared this statement to provide a brief overview of Ryman and our interests in this present process. Ryman is New Zealand's leading retirement village operator. Ryman was established in Christchurch in 1984 and now operates 38 retirement villages across New Zealand. Our villages provide homes for more than 13,200 elderly residents and employ over 6,700 people. Ryman is considered to be a pioneer in many aspects of the healthcare industry, including retirement village design, standards of care and staff education. Ryman is not a developer per se. Ryman is a resident-focused operator of retirement villages committed to providing the highest quality housing and care for New Zealand's elderly residents in its villages. Widely published population statistics, as referred to by Mr. Collins, strongly support a growing need for further development of retirement villages and care. In Wellington, our villages combined provide a home for over 1,920 of the region's ageing residents, including approximately 80 residents originally from Porirua and a further 290 Porirua residents on our wait lists. Ryman was recently granted consent for a new comprehensive care retirement village at a nearby site in Karori, Wellington City. At the time of the consent hearing, Ryman already had a list of over 440 people who had expressed an interest in living in this village. This number has since risen to 706 people, and this interest is without any official marketing. Ryman also experiences a similar level of interest for other villages in Kilburnie, Kundala, Waikanai, Petone and Lower Hutt. This strong interest shows the desperate need for comprehensive care retirement villages. This need has been exacerbated due to closures of smaller, poor quality aged care homes of the past, which are often conversions of old houses that are simply just not up to standard. Ryman has a large pipeline of units for development in the Wellington region over the next 4 to 5 years that may go some way to alleviating the short-term anticipated shortfall in the supply of quality aged care and living options in the Wellington region and Porirua. However, further development of new villages beyond the current pipeline and within Porirua is needed to meet the long-term shortfall. The importance of providing more retirement accommodation and care in Porirua is to meet the needs of an ageing population needs to be expressly recognised in all appropriate zones. In this regard, I disagree with the Council Officer's view that it is not necessary or appropriate to single out an outcome for the ageing population. I also note that as Ryman residents move into a village, they sell the family home. Therefore, every new Ryman village will release approximately 300 to 400 family homes back onto the market to be more efficiently used again by families desperate for homes, and this can assist with the broader housing shortage. We have extensive experience in RMA planning and consenting processes. Many of our recent villages have been through notified resource consent processes. In those processes, the needs of our residents, the social and economic benefits of our villages, and functional and operational requirements for the layouts of our villages are not given sufficient attention. Instead, the focus has tended to be on neighbouring resident amenity interests and concerns. We have also found that district plans around New Zealand are inconsistent and often poorly provide for retirement villages. These two factors have led to major delays in providing much needed housing and care. As with Mr Collins for the RVA, Ryman is very encouraged by the new direction in the government's enabling housing legislation. We are hopeful that this process will allow the balance of considerations and consenting processes to be reset appropriately. I acknowledge that Variation 1 and Plan Change 19 provide a degree of recognition for retirement villages. However, more is needed. There also appears to be some significant misunderstandings by the council officer regarding the nature and features of retirement villages. Ryman has regularly faced challenges in consent processes where retirement villages are viewed as mixed residential and commercial or hospital use, which also appears to be the view of the council officer. This leads to lengthy debates about the activity status and assessment requirements and has generally increased the risk of Ryman obtaining consents. As outlined by Mr Collins, retirement villages are clearly residential in nature. They provide permanent living accommodation to residents. Our residents describe the villages as their homes. Any ancillary activities or facilities are for the residents and their visitors, and such facilities are important as many residents are unable to easily travel to access other amenities and services. Ryman considers it of utmost importance that the district plan expressly recognises that retirement villages are residential activities. Although retirement villages are residential activities, their unique functional and operational needs mean they often do not fit in with typical urban design rules for residential development. Because of the comprehensive care nature of Ryman's villages, all of the communal amenities and care rooms need to be located in a central village centre building to allow for safe and convenient access between these areas. Many of the shared amenities are indoors, which is more comfortable for older residents. And many of our units are designed for specialist care, meaning they may not have kitchens or private living areas. These operational requirements result in a density and layout that differs from a typical residential development. However, often communities, particularly neighbouring landowners and council officers, can have an expectation as to how sites are going to be used. Typically, that expectation is not for medium or high density retirement accommodation that zoning provisions allow for. In some cases, council officers may even attempt to redesign the village layout and focus on internal amenity issues which are best left to us as the specialist operator. This is partly because planning provisions have traditionally ignored the unique features of retirement villages. As a result, consenting of retirement villages has been unnecessarily complex and time-consuming. When consenting our Karori village, Ryman made a significant effort to produce high-quality architectural design which made a positive contribution to the surrounding neighbourhood. The proposed village has generous setbacks and building forms which comply with height in relation to boundary controls and which were thoughtfully stepped in height on sensitive neighbouring boundaries. However, many submitters still argued that there should be even greater setbacks and height reductions, well below the permitted thresholds of the relevant building standards. Dealing with these requests took up considerable hearing time and caused major delays. These issues emphasise the need for fit-for-purpose retirement village provisions that recognise the unique features of retirement villages. I also record that I do not agree with that these features result in more effects as suggested by the council officer. In my experience, Ryman's villages are good neighbours and fit in well with the planned character of the area. I also note that we do not seek special dispensation from the plan's bulk and location rules that govern external effects on neighbours. We expect these to apply to our sites and we use them as a key guide when designing our villages. In relation to our request to recognise the intensification opportunities provided by larger sites, this relief sought is in part due to the lack of suitable sites to provide for retirement villages. As Mr Collins notes, retirement village residents want to remain close to their families, familiar amenities and other support networks, and they want to age in place. However, sites that are appropriate for retirement villages are rare due to size and locational requirements. Therefore, it is important to Ryman that retirement accommodation on all appropriate sites is encouraged and enabled. I also note that large sites provide significant opportunities to internalise effects. For example, we can provide larger setbacks and step building heights away from neighbouring boundaries and put service functions in areas that ensure minimal off-site disruption. These design options allow us to achieve medium to high density without impacting neighbours. It is thus important that the district plan expressly recognises the intensification opportunities provided by larger sites. Ryman agrees with and supports the key outcomes sought by the RVA, as previously set out by Mr. Collins and soon to be, and has been expanded on by Mr. Hinchy and soon to be by Mr. Mitchell. Thank you. Happy to take any questions.
I have no questions. Anything, Commissioners?
Yep.
I think that's the benefit of going second.
So, no.
What?
No, I've got a question. Yeah. So, in paragraph 18, you say due to the size and locational requirements for the sites for retirement villages. So, what's the locational?
Well, as I said, our residents like to age in place, so the locational requirements is about being in residential areas and with, still close to some amenities. So retirement village residents that are still living independently still need access to supermarkets and medical centres and pharmacies and that sort of thing. But also, as I said, residents coming into villages still want to be close to what's familiar to them. So, if they've lived in an area for a long time, then they will have other social activities that they would, prefer to be close to. They'll have a doctor that they've been seeing for however long that they prefer to be close to. So that has a big impact on where villages should be.
Right, thank you.
One question related. You said needs to be expressly recognised in all appropriate zones. What are the appropriate zones?
Well, residential for one. From a technical point of view, might be a question better answered by Mr. Hinchy or Mr. Mitchell.
All right. I think we'll hear from Dr. Mitchell.
Thank you, sir. Good afternoon, Commissioners. It's getting late in the day, and rather than going through chapter and verse of my written statement, which you've read and mentioned there, I just want to highlight several key points that I think might assist the panel. And if I could just respond firstly to comments that the Chair made earlier and said, well, given that the Section 42A report accepts a range of propositions, what's the problem? And the problem is not so much that one is right and one is wrong. It's the fact that the regime that we have proposed is, and that's the one word that Mr. Hinchy didn't use, is clarity and expectation. And my view of any planning document, whether it's this one or another one, is that there is something that needs to be said that's specific to a particular scenario, then it should say that so that there's no doubt. And I think, as I explained in the Wellington strategic context, the changes that are being proposed are relatively nuanced. It's not that we're looking for, a brand new regime. What we are looking for is a regime that specifically recognises some of those nuances that apply to retirement villages. And I'll explain a little bit more about that in a moment. Just also, again from the chair, made mention of the National Planning Standard definition and that the ancillary activities just said that they had to be for their residents. And there was a question of, well, what if it's partly for the residents or just a little bit for the residents or not solely for them? And I think the short answer to that is that if you were, for example, and using Mr. Hinchy's example, proposing to put a commercial cafe on the street frontage of a retirement village, it would trigger other rules in the plan, almost certainly. I mean, it would not be a facility for the residents. It would be a facility partly for the residents, but also for a range of other users. And as a consequence of that, it would be a commercial activity or whatever the plan decided that the proper classification of them would be. The fundamental difference between the 42A report and the Ryman/RVA proposition is around how to give effect to the higher order statutory documents. And Ryman has, and I've set them out at my paragraph 20 of my executive summary, Ryman has proposed, and this is at paragraph 20.3 in particular, has included 3 new policies that are retirement village specific, and has sought, and I haven't said that in the summary, but I have in the bulk of the text, and that they should replace policies 5, 7 and 8 of the residential chapter. Because I think if you look at policies 5, 7 and 8 in the notified version, it's almost you wouldn't know by looking at those that there was an NPSUD that requires intensification and for the plan to give effect to the objectives and policies of the NPSUD.
Dr. Mitchell, could I just ask a question there while you're on that 20.3?
Sure.
The new policy, the 3 policies, how are they specific to the retirement village?
Well, those particularly are not, and I think that is a fair comment. But what they do is give effect to the NPSUD in a much more whereas policies 5, 7 and 8, in my view, don't. But what they do with the objective 20 that I've set out in 20.2, what they do is provide a context for the implementation of that objective.
Yeah. So, but
and then,
isn't
sorry,
the policy though supposed to give effect to the objective under Section 32?
Yeah, well, that's what, if you go carry on into 20.4,
right,
that's the one that deals specifically with retirement villages.
Right. So yeah.
And if you look at the 3 extras in 20.3 and the amendment to 13 that's in 20.4, then, and I think that if you look at my page 7, you'll see in the deletions why, in my view, those provisions that are shown in strike through on page 7 and onto page 8, you'll be able to see from them why they are very much focused on a pre-NPSUD world than they are on one looking forward from now, in my view.
But do your replacements in 20.3 A, B and C, do they only apply to retirement villages, or are they supposed to apply to all other housing situations?
The latter.
Thank you.
Please keep going.
And I'll be guided by you, Mr. Chairman, but probably the other key point is the one that I've set out in my summary at paragraph 20.1. and that is that there needs to be a definition of what a retirement unit is. For the reasons that the earlier witnesses and Mr. Hinchy have said, a retirement unit has special characteristics that distinguish it from a conventional residential unit. And the witnesses have explained what those are, and I don't need to labour that point, other than to say that things like amenity are often provided in communal facilities rather than individuals. The need for outdoor living spaces that are private and in relation to a particular unit don't apply, those sorts of things. So I think of all the things that are important, that's really fundamental from my point of view.
Sorry, Dr. Mitchell, could I just ask then, that the definition for retirement unit, sorry, I couldn't find it in the new objective or policy. Is it identified in there?
Sorry, I don't follow. So can you explain what you mean by that, please?
Sorry, you got a definition of retirement unit.
Yes.
Where does the term retirement unit appear within the objectives and policies or the other amendments that you've suggested to make to the plan?
It doesn't apply specifically. What it does do is exempt it from the built form standards that apply to conventional residential units. That's the point of it.
While we're on that, the recommendation from the 42A author is to exempt retirement villages from all of those same standards. Don't we get to the same place?
Well, we may do, and I accept that as a general proposition, but I come back to the point that I said right at the very start, that clarity is really important. And if the intention is to do that, then I prefer it to say so in black and white rather than infer it, not now, but when someone picks the plan up and looks at it and tries to interpret it.
In that case, should the retirement village specific policy, if we're looking for clarity, say more clearly that the plan is not concerned with the internal amenity within the retirement village, but is only concerned with the external effects of the retirement village on the surrounding community?
Yes, I think that's helpful.
And in terms of the policy that you've suggested, the new policy, providing for more efficient use of the site, is that coded language for a higher built form and a more dense rate of development? And if it is, should we say that?
Well, perhaps we should. And I think the purpose for that has been explained by the earlier witnesses, and that is because if you're concerned about, for example, effects on neighbouring properties and things like shading and bulk and so on and so forth, if you've got a very large site, you can increase, for example, the height in the middle of that site without affecting neighbours at all, because the property across the fence, the light and so forth that it will get will be dictated by the townhouses or buildings or whatever they are that are immediately adjacent to that boundary, provided that the central building is not too big. And I'm not sure if I've explained that very clearly, but if you've got a neighbouring property that when you look across at it, it's 2 stories high, and the plan says that's what's appropriate on the boundary, and you've got 4 stories behind that, but the line of sight from the boundary means that the 4 stories is hidden by the 2 stories, then in terms of recognising that the efficiency that's gained by going to 4 stories in the middle, that can only be recognised or realised on a large site. You can't do that on a small site. And as I think we tried to explain in the Wellington hearing, the larger sites are pretty rare and they need to be developed effectively and efficiently if the value of them from a wider perspective is able to be realised.
Again, calling a spade, if we want to be clear what we mean, should the policy say something like recognise that higher and more dense development is possible on larger sites, provided they're designed to focus, this is making up on the fly, to focus development on the centre of the site and using the size of the site as the flexibility provided by the size of the site to minimise external effects, something like that, to capture that idea that Mr. Collins and Mr. Brown said. These retirement villages build big central facilities that are a long way from the legal boundaries and a long way from any neighbours, and that should be recognised. But equally, you don't want to provide something that the highest building is right on the boundary, and that's the message you want to send.
I think that's true, but using that as a for instance, Res Policy 9 already deals with the effects of shading, for example, and how you deal with, and P10 deals with developments not meeting permitted activity standards and so forth. So they are already there, in my view, because you would look at it and say, well, using shading as the example, the shading is already determined by the building on the boundary. Therefore, the centre of the site doesn't matter in that regard. But having said that, I'd have no objection at all to clarifying the situation along the lines of what you've suggested, sir. Because it provides greater certainty and greater clarity about what is intended. Because it's certainly, and I need to stress this, and I'm not trying to advocate on behalf of my clients, but if you look at all the villages and the Ryman ones are the ones that I'm familiar with, that's the approach that they take, because they know it doesn't make sense to try and put all the bulk against the boundary because of the effects that it causes. But I have no objection to what you've suggested.
And the last question I have related to your revision of Policy 13.
Yes.
And what's conspicuous to me is that it no longer says anything about how effects are managed. And so even if the intention is they will be managed on the basis of the same standards as are stated in other policies, should the policy say that?
I think that's probably helpful. I mean, it's implicit in my evidence, and if it isn't explicit, it should have been, is that there are other objectives and policies in the residential chapter that also apply. And this is not meaning to circumvent them. What it is doing is wanting to get positive recognition for the sorts of things that you and I have been discussing in the last few minutes. But if it were to be made clear that those other provisions still apply, then I'd have no objection to that either.
Any other questions, Commissioners?
Just one question from me, Mr. Mitchell. I'm not sure that we completely tied off Commissioner St Clair's question about the residential unit. Can I clarify with you that what you would like is a new definition, but you don't link it to any objectives, policies, rules or standards? It will sit floating in the plan as a definition, but without a link to something?
Well, it links to the retirement village definition. That's where I think it belongs, because it's a unit within a retirement village. So it's covered by the retirement village provisions, but there's no specific mention of a residential unit. And I think the reason for that is that there's no need to specifically address it, provided that you say the general provisions that apply to all residential units must apply to retirement units. It's the fact that they're part of a retirement village and are not residential units as a consequence of that. That's the key point. So I don't think they are left floating, as it were.
No. So, I mean, to carry that line of thinking through, you'd then want to amend the definition of a retirement village, would you, as well?
No, because I think the National Planning Standard makes clear what the definition of a retirement village is.
Could I just, sorry to interrupt there, I just thought it might be helpful to clarify and take you to the submission points which deal with that retirement unit point, because we probably are, the officer in the industry is saying similar things, but the actual regime that is being promoted by the retirement sector is actually probably got a bit more detail around the retirement unit. I don't think Dr. Mitchell included in his evidence, but it's probably worth touching on pages, if you've got them there, 34 and 35, which relates to the high density zone, and later the provisions which deal with retirement units at 39.
Sorry, whose evidence are you referring to?
The submission.
So I'm referring to the submission point. We didn't repeat chapter and verse, I don't think, the actual regime, but just from my point of view, to explain the retirement unit definition point, the definition, I guess, is there to, I guess, look fairly similar to a residential dwelling definition, but it's it doesn't require you to have things like kitchens, because not all retirement units have kitchens. So it's dealing with the sorts of units that Mr. Brown and Mr. Collins were referring to, where it's still a house or a home essentially, but it doesn't have all of those same things. But then the internal amenity controls which apply they're still similar to the residential dwelling ones, but they're not the same, because the retirement units, as Dr. Mitchell was saying, is they're not necessarily going to need all of that same outdoor living space or outlook space as a residential dwelling is. But there's still a series of controls which will apply to residential units, mostly in and around that, things like outlook, outdoor living space, landscaping requirements, and those sorts of internal things. We're not seeking a regime which has no control over internal amenity. It's just, I guess, a more nuanced approach for the industry. Following
up on that, Mr. Hinchy, when I was preparing for this hearing, I did a word search of the RVA submission, looking for every reference to retirement unit. And it struck me that while you're not asking for an exemption from the normal rules that govern internal amenity related to residential units, that's what the 42A authors are offering you, because they're a complete exemption for retirement villages from all of those standards. Now, if you tell us that you don't want that exemption, then we'll carefully note it down and figure out where that takes us. But in the nicest possible way, is this really where you want to go?
No, I hear you, sir, and to be open about it, we have sought regimes in other councils that have no internal amenity controls, and in Christchurch Replacement District Plan process, the panel approved that. They agreed that there was no need to control internal amenity for retirement units, because it's all dealt with through the specialist operators, that create these things. In this case, we'd put up a regime as a start of a 10 that actually sort of tries to match the MDRS. But as you say, the officer has taken this to another level, and we're not going to disagree with that. I just wanted to make that clear, because I know that this will come up in other hearings that you're involved in, Mr. Chair, and I just that we were originally seeking, that those retirement unit provisions do have some internal control. But if it's not resisted from the officer, we're happy to follow suit. I would have thought I can seek instructions on that, but
well, let's just say I'm looking at your clients and thinking this is why look a gift horse in the mouth country.
Yeah, no, that's fair. I just wanted to be open and transparent about the position, and we'll probably roll with the council officer on this. I'm looking at Mr. Collins and Mr. Brown if they want to make a comment on that at this point.
Okay, well, Mr.
We
Hitch,
might come back to you on that, sir, by the sounds of it.
if you're going to come back to us, it needs to be soon.
Yeah, it will be.
And like certainly before the end of this week.
Absolutely, no, we can do that. The only other point of clarification I was going to make was just in terms of the, there's a question about the policies not sort of managing effects, but there's a detailed restricted discretionary activity regime, which does, I guess, pick up all of those effects assessment points. And again, it's not the same way that the council does it, but it is still a regime of effects assessment, which, I'm looking now at page 34 of the submission, deals with things like, the extent of effects resulting from infringements of the built form standards, the effects of retirement village on the safety of adjacent streets, the extent to which articulation, modulation, and materiality addresses adverse visual dominance effects associated with building lengths, the effects arising from the quality of the interface between the retirement village and adjacent streets or public open space. All of those are, seeking to focus the effects assessment on the particular things that we say the NDRS are concerned about in terms of these sort of multi-unit type scenarios. So just to fill that out in terms of what Dr. Mitchell was saying, that's where the rubber hits the road, I suppose, rather than asking the policy to do the heavy lifting.
And this comes back to a planning style point, whether you have assessment standards or use your policies as the assessment standards. Dr. Mitchell, do you have a general view? I think there is a danger that I've seen a lot of plans where assessment standards are rehashed versions of the policies, and then lawyers make a lot of money exploiting the differences in the way that the two are worded.
I can't comment on the lawyers making lots of money point, but what I would say is that, objectives lead to policies which lead to rules. So the specifics about what's live and what's not live should be in the rules. And I don't think it's appropriate for rules to restate policies. That's point one. And nor do I think it's appropriate to have hugely detailed policies and very short, succinct, imprecise rules. So I think you've got to look at it as a cascade, and that would be the conventional way of looking at it. You start with the general and the high level aspects at the objective level, you give effect to those in the policies, and then you explain in the rules what the relevant considerations are.
Any more? I think that's it from us. Do you have any final comments from the retirement team?
So there's just one from me that I should have highlighted and didn't. And I think it's a misunderstanding between the officers and ourselves, and it's the same issue that arose in Wellington. And that is, we are seeking a distinction between the use of a retirement village as a permitted activity, as opposed to the built form standard and the construction and operation of the buildings themselves. And I think there might be something's been missed in translation between the submission, the 42A report, and ourselves back again. But that's the only point that we're making in relation to permitted activity matters in relation to land use. And that's just legitimising the point that retirement villages are residential activities. And it's the effects of the use of them, of the buildings, that is where the, using your term, rubber hits the road. That was all I had. Thank you, sir.
Thank you. I think that we're done for the day. Some of us have had a long day, so we're going to adjourn the hearing at this point. Thank you to the Ryman and Retirement Village team Appreciate your attendance and participation. Look forward to hearing from you, Mr. Hinchy, before the end of the week on that point about internal amenity standards and,
Yep, understood, sir.
and residential and retirement units, and then we'll go from there.
Thank you very much, sir, and
Yep.
thank you, Commissioners.
And we'll adjourn until 9 o'clock tomorrow.
Chair, can I just provide an update on our tomorrow? So I finally heard back. Neither of them are in today. One of them is in tomorrow morning, but I won't have had time to get them to develop the illustrative material.
Sounds like Wednesday morning.
So I was going to suggest if we can park it to the Wednesday morning, at some point when I finish tomorrow, I can then go through and actually work on the presentation on that.
Okay, we'll proceed on that basis. Thank you.